All right. Good morning, ladies and gentlemen. We appreciate all of y'all coming, especially with the weather that's outside. Those of you that are at home or at your computer at your office, I hope that you're high and dry. In Pascagoula right now, we're on a tornado watch, so we're going to have to hopefully protect that and go on today. On behalf of our law firm, Heidelberg and Steinberger, and the Gulf Coast Human Resource Association, we welcome you to our annual seminar. We've been doing this for at least 30 years. We're really happy to have live people, though, here today. We've had the last 2 years just pure virtual, and I really enjoy a live audience. So I appreciate y'all being here and can participate in our seminar. I want to thank my staff for helping put this together. Tristan's doing a great job with the WebEx. Terry Harvey and Alicia Harris, Casey Bloom, Candace Atwood. It takes a team, an effort to put our seminar together, and we appreciate them doing that. Those of you that need credits, we'll have some certificates here you can ask, but the best way to get your credits is to go to the website, and you'll see a link, and then you'll fill it out and follow the instructions on the website. Dusty Pisarich is here for the Gulf Coast Human Resources Association, and she'll talk a little bit more how HR can get your credits either here or online. We are going to get the property and casualty credit as well. So if you'll try that first, if you have any problems, you can call the office and ask for Terry, and we'll make sure all of you get the credits that you deserve for being here today, 3 1/4 credits. The speakers today, I'm Carl Steinberger, Tristan Armour, April McDonald, and Stacy Zorn will be here in a little while. We're all in our law firm of Heidelberg Steinberger and do employment law and workers' compensation. And so we are going to do our presentation. The first thing I want to talk about is our book. Now, all of you who are live here today have one in front of you. All of you who are virtual, if you look on the website, you can download this book. We've been publishing this book for probably the past 30 years. I feel like we've got a little edge over our competitors with the book because we update it every year. So you'll see in this book down in the bottom section that there's bold sections of the new cases that have come out every year. And so it's designed for workers' comp. It was designed for workers' comp adjusters. We really left a lot of the legal things out. It's got a lot of the principles and some how-to things I'll talk about in a minute that I think can help you learn about workers' comp. If you read it, if you have questions, you can feel free to call us about it. It covers a lot of different areas. Every year I've been doing this for a while. The way it works is you have a case. We use the law. It's based upon the workers' comp statute. It's not very large. It has procedural rules and it has general rules. Then the Mississippi Medical Fee Schedule has a section in it that has some rules as well that we look to. You start with that, then you go to administrative law judges who write opinions. That goes to the Mississippi Workers' Compensation Commission that writes opinions. That can be appealed to the Mississippi Court of Appeals and then to the Supreme Court. And so we as lawyers are going to read those, and then we can give advice on how the courts have interpreted the statutes, the regulations that are in the book. And so what I do every year is look at the new cases that have come out in the last year and pick one that I think might be of interest that's a little different. So I've picked this one. The name of it's Kroger versus Pybus. And what you have is the facts of Ms. Pybus. Her name is Kathy Pybus. She's 66 years old. Y'all can read along with me. She's a grocery clerk. She's knocked to the floor by a customer. She hurt her pelvis in 2015. She had 2 surgeries. She was declared MMI. Tristan will talk a little bit more about MMI, maximum medical improvement, where you reach a plateau when you go back to work, you hope. Her doctor said that she was cured, healed, and then I got to stretch over a little, read this a little. The doctor was released her to return to her normal activities with restrictions. She had, I think, a 10-pound lifting restriction. She returned to work to her former job as a grocery clerk with that restriction. She received raises after she was there. She was paid her temporary disability, so when she's off work, they pay workers' comp benefits, but she was not paid any permanent disability. She had gone back to work, making the same or greater pay as better than her average weekly wage. And that is the issue in the case. The case is whether or not she's entitled to permanent disability benefits while she's gone back to work. So they couldn't agree to settle the case, and it goes before the administrative law judge. And the judge, she testified at that hearing, and you can see what she said. She's a high school diploma. She's got a work history of 12 years as a grocery deli, 5 years in a bakery. She's working, she says, only because they are allowing her to work with her accommodation. Otherwise, she says she couldn't work, was her position. And she said she had pain when she was working, but she was doing her job. The next witness was James Smith, store manager of Kroger. He said, yes, we've given her this accommodation, and she's doing a fine job when she's working there. He said that she did get raises, and he admitted some of the raises were union raises rather than merit raises, and that he felt that everything was fine. So the lawyers for Ms. Pybus hired a vocational expert, and this is the reason I selected this case. This particular vocational expert, her name is Kathy Smith. She said that that 10-pound restriction restricted her to sedentary to light duty work, sedentary to light duty. And she used as the basis of her opinions a thing called the loss of access report. Now, this loss of access report is something that's been in the courts. It's prevalent in some states. Alabama uses it a lot. It's not used in Mississippi and very much, and it hasn't been recognized in Mississippi. It's a different approach than the traditional vocational assessment, where a vocational expert meets with the claimant, tests them, and then finds actual jobs. The loss of access report does not find actual jobs. It takes all the statistics, age, work experience, restrictions, and comes up with a percentage of jobs that this claimant can no longer do in the national workforce, regional workforce, and they say some local workforce. And so she presented this program, or this results, a statistical approach from the computer, and it said that she had a 96.6% loss. That basically said she can't find a job, even though she has a job and is working at Kroger. So that was one expert for the claimant. The employer and carrier hired the traditional experts. Her name is Angela Malone. She didn't agree with Ms. Pybus. She said it wasn't sedentary to light. She said the 10-pound restriction was light to medium, which opens a lot more jobs that would be available to her. She met with her, she conducted testing, and then she went through and actually found actual jobs that she could do other than Kroger. That's the question of what is your loss of wage earning capacity? And so her loss of wage earning capacity is based upon what jobs she can find. And she found actual jobs, and then she criticized this loss of access report, pointing out that it was not real jobs, that it's based upon this survey, the national statistics. They also had a report from a vocational expert named Bruce Bronner. He worked with Ms. Malone, and he agreed with Ms. Malone that this was light to medium work, and he also found actual jobs that were in their reports. So as I mentioned earlier, the job of the administrative law judge is to apply the law, and that's what we lawyers do for our clients, is we read the law and give you advice on what the law says. And now this is what the law says on this topic. I'm going to read it with you. Where an injured worker returns to the same or similar employment and earns the same or higher wages, the rebuttable presumption of no loss of wage earning capacity arises. What that means is if she's back at work, making the same or greater pay, then there's a presumption. That means it's probably the law is going to not give permanent benefits. You get your temporary benefits, but not benefits. And these cases go off on the principle that an employer, it should be encouraged to allow injured workers to go back to work. Now, this case law was stronger years ago than, as the HR people know. We now have the ADA, where the ADA designates if you're a qualified individual with a disability, the employer has an obligation to provide a reasonable accommodation. And so I think Ms. Pybus would qualify as being protected under the ADA, and this employer, Kroger, under the federal law, had an obligation to provide a reasonable accommodation. But that is more limited than what workers' comp employers have been doing for many years in allowing injured workers to go back to work. They recognize the fact that they want to give them a job, and you'll find that the insurance industry, and I as an insurance defense attorney, have encouraged employers through the years to try to allow injured workers to go back to work, find a job for them and accommodate their disabilities. Now, the law says there's a presumption, but the law also goes the other way. That presumption can be rebutted, is the way it's phrased. And so in this case, the claimant is saying this presumption was rebutted, and the law has criteria, and that's what I'm going to read to you now. If the claimant can show there was an increase in general wages, well, there was, that she got a raise through the union. As an injured worker has a more maturity and training. I didn't find any of that in the case. The injured worker is working longer hours. That was not in the case. The employer, this was all sympathy for the claimant. You could see where that would happen, but that wasn't in this case. And the character of the post-injury wages are unpredictable. Now, that issue is kind of up in the air. As all of you know, Mississippi is a terminable at will state. So an employer can terminate someone for any reason as long as it's not an illegal reason or reason prohibited by federal law. So you could argue that the job is unpredictable, but on the other hand, in these facts, there was no reason to believe that Kroger was going to fire her. She was doing a good job and she'd been a valuable employee. So it's a balancing test on that question. And any factor which causes the post-injury wages to be less of a factor of the loss of wage earning capacity should be considered, and that included such things as they mentioned, the loss of access. Now, we've got to remember too, and this is something we've always preached, that if in fact an employer refuses to allow an injured worker to come back to work, then there's a presumption of total disability. And that's one reason why in workers' comp we encourage employers to allow claimants to come back to work. And in 2015, the value of a total disability case was $195,973. So that's a balancing test too for this employer and this carrier in this case. So it goes before the trial's over. At a trial in Mississippi, it's not quite like Judge Judy. But the judge is in the front and the witnesses testify and the evidence is presented. A record is made by a court reporter for an appeal. Before that, there was discovery, depositions, and questions and other procedures before there's a trial. And in this case, the judge then renders her decision, and the judge followed the traditional rule that the presumption of no permanent loss of wage earning capacity applied and denied the permanent benefits and repeated that traditional statement that employers are encouraged to allow injured workers to return to work. And no surprise, Ms. Pybus appealed that to the commission. Now, the Mississippi Workers' Compensation Commission is comprised of 3 commissioners, Mark Formby, who is the employer's representative, Beth Harkins, who is the claimant's representative, and Mark Henry, who's the attorney. That's provided in our statute, and the governor appoints the 3 commissioners, I think, for a 6-year term. And they meet. It's unusual in Mississippi. Lawyers recognize it unusual. You do not have to be a lawyer to be a commissioner. So Mark Formby and Beth Harkins are not lawyers. Mark Henry's lawyers, and they have lawyers on staff at the commissions. But they read this, and they made a decision that they agreed with they did not agree with the administrative law judge. They felt that the presumption was rebutted. They pointed out that she had the restrictions. She didn't have these restrictions before the injury, as you can see, that the employer was accommodating the restrictions, and that she complained of pain. They pointed out that the post-injury earnings are unreliable. I mentioned that, the terminable at will issue. So they went on that, and they relied very heavily, in my opinion, for the first time, the commission relied very heavily on this loss of access report prepared by Kathy Smith. And they pointed out that she was entitled to permanent benefits, and they gave her $63,000 payable at 450 weeks for her permanent disability, even though she was working and making more money than she was at the time. So guess what? Kroger appeals. Kroger appeals the case to the Court of Appeals. Now, those at home I can't see your vote, but I want to see the group that's here tell me who believes that the Court of Appeals is going to affirm the decision of the commission and give her the $63,000. Raise your hand. It is a liberal statute, isn't it? Who in the group believes that the Court of Appeals is going to deny the permanent disability? And I have an overwhelming show of hands on the denial by about two to one vote. Well, those who believe it was going to be denied are wrong. The Court of Appeals agreed with the commission. They found that she did go back to work, but she was accommodated. She was 66. She had work restrictions. And notice they used light restrictions. So they just bought into the Kathy Smith expert as opposed to the other two. And that she had this pain factor. The presumption of the permanent disability was rebutted. And they said that she was entitled to the $63,000 plus she can go back and keep her job. So what are the takeaways from this little presentation? First, if you don't have ADA job descriptions for your workers, you need those. You need written job descriptions that are ADA compliant, that have the physical restrictions. That would have made a difference. They never talked about that in this case. As I said, this is, in my opinion, this is showing a new trend. What that means is the insurance industry and employers need to recognize that when you give a job back, that it may not save you the money that we thought that it was going to. Because of this, this is a trend that we have to be aware of. And I always encourage my employers to keep up with what goes on with your workers' comp cases. Be in communication with your adjusters. Talk about what the factors are and discuss this kind of situation. You can tell them, you went to this seminar and heard Carl say that we need to look at this when we allow injured workers to return to work. We need to be more aggressive, I believe, in showing to rebut this loss of access report. There's a lot of reasons why I think it's not a reliable, it's a factor, yes, but it's not something to rely on solely or as strongly as I think the commission did in this case. I think that you still have to recognize when you're allowing the claimant to return to work, it may cost more, but remember, you don't want to risk a permanent and total disability of the $195,000 either. So it's not, I don't have a good answer. This is just sharing with you a trend, a change in the law that's happened that I think you need to be aware of when you face this issue of allowing claimants to return to work with restrictions. All right, I'm going to turn this program over now to Tristan, who's going to talk about elements of a claim, benefits, and bad faith.
Good morning. Again, this year, we're once again doing our seminar a little different. We've done this, I don't know, Carl, how long have you been doing it? 30 years? Yeah, and this is the first time we've sort of done live in front of a studio audience. So thanks for showing up. I was tired of talking to folks through a computer screen. So I said, you know what, we need to have face-to-face time. I certainly appreciate that and that y'all came today. And you know, let us know at the end of the seminar. There'll be a survey if you do prefer it live or by video, or this kind of hybrid approach where we do both. As Carl said, you kind of covered this new case. Look, if somebody gets hurt at work, how do they claim, or what do they have to show to claim workers' comp benefits? That's really what we're going to cover. And then what benefits are, what you get when you get hurt on the job in the line of scope of your employment. And then the last thing we'll touch on is bad faith. That's sort of the big no-no in Mississippi. If you want to get sued for a lot of money as an employer, you'll engage in acts of bad faith. If you don't want to get sued for a lot of money in Mississippi, then you won't. We always say in Mississippi there's 3 elements to a workers' compensation claim. The first one, you got to have some sort of accident at work. All right, and I can tell you that an accident in Mississippi is as simple as, man, I bent over to pick up a pencil and felt my back pop. All right, very slight, any unexpected result from a routine activity can be called an accident. Walking and feeling your knee pop is a very common question I get from employers. Is that covered? They're just walking at work. Well, it is an accident. By normal activity, they had an unexpected result, an extra strain, and that is an accident or job-related injury. The second thing they'll have to prove is some disability. You get medical treatment. Let's say you cut your finger and you got to go to the doctor to get it stitched up. All right. You're probably not disabled from work. You can probably work with a paper cut on your finger. But the fact that you had to sort of leave the job and go to the doctor, just again, that slight removal from the ability to sit down your regular normal course and job and earn wages is disability. In fact, that's the statutory definition. Any impairment of the ability to earn is a quote disability. Now, in the common sense, that's not a disability. For workers' comp purposes, that's all you have to show. Some incapacity, some diminishment of the ability to earn wages. And then the last one, and this is usually what most cases that come to lawyers are squawking about, and that's called causation. You get a lot of, as we have an older workforce, all right, my back aches, I got it. My back aches, I'm a lawyer, I get to sit down all day. But is there a link between what happened at work, bending over to pick up a pencil, and my back aching now? And that gets contested a lot. And I guess it's this. We rely heavily on physicians' opinions. Expert evidence, expert medical evidence is generally required by the employee. So if the employee can simply just say, hey, I bent over to pick up a pencil and now my back aches, as an employer, first question is, well, have you seen a doctor and what's he say? The trouble gets to be, I had a conversation over some smart juice with a doctor the last couple of weeks, and he is a relatively new orthopedic physician, and he kind of asked me how he was doing. I said, you're a great doctor, you're a rotten witness. And he said, what do you mean by that? I said, well, look, you're accepting what the injured worker tells you without rendering your own independent opinion. I don't want to know that the employee says he bent over to pick up a pencil and his back aches. I want to know what you think. And you have to stand tall and give me your expert medical opinion. And that's something as an employer you should look for. The claimant has the burden of proving the link between what happened at work and why he's disabled or injured today. There's some special cases in Mississippi. The found dead presumption, and it works just like this. If you go to like the person's desk and they're slumped over dead, no matter what the reason may be, at that moment it's presumed to be a work-related death. Right now, you can go get an autopsy if the family will let you, or maybe track their medical records. And the day before they went to the doctor with serious, heart rhythm problems or things of that nature, and unprove. But if somebody's found dead at work, there's a presumption. And again, when we use presumptions, we throw that around as lawyers. You've all heard you're presumed innocent until proven guilty, right? It means when you walk in a criminal case, if nothing gets proven, you get to walk back out. The evidence must overwhelm you. And it's the same. If you're an employer and somebody is found dead, you will be paying workers' comp benefits unless and until you can show their death was non-work related. Heart attack cases. In Mississippi, you can, if you have a heart attack on the job and you're a claimant and the claimant can show some extraordinary exertion, then that heart attack is a job-related accident. Now, I know what you're saying. You're like, well, look, they never worked out a day in their life. They kind of had a fetish for fried chicken and 12-pack of beer and a case of Marlboros. I mean, why am I paying for the heart attack? And there is, and Carl talked about the apportionment. And again, all right, they got a bad heart. They're kind of a fragile employee. But if you've got them lifting 80 pounds routinely and it's 120 degrees and they overexert themselves and have a heart attack, some component of it is work-related. In those heart attack cases, again, the benefits, medical benefits get paid, but the disability benefits get split. It's called apportionment, and Carl hit that a little bit later in more detail. Occupational diseases, this is your carpal tunnel or asbestosis, things of that nature. There's a little heightened burden of proof on the claimant's part. They got to come strong with some evidence, but in practicality, it works the same. If they've got a physician backing them up saying they have this particular disease and it was caused or aggravated by exposures at work, carpal tunnel, asbestos, then it's compensable. And in Mississippi, unlike some states, there's a split in jurisdictions. Emotional injuries, right? Now, the law is pretty clear that just being sad and upset is not an emotional injury. I think you'll get some employees that occasionally will make a claim for that. A purely emotional injury has to be severe, and the burden of proof is what we call clear and convincing. The example I had is a very compensable emotional case. Guy was driving a semi, truck pulled out in front of him, big collision. He got out of the truck and saw the dead person right as he exited the cab. We had surveillance on the guy. He grew a long beard, never left his house. Okay. He had true post-traumatic stress disorder. He was not ever going to go back driving a truck. He feared it to death. Okay. No physical injury, definitely an emotional one. He is entitled to his disability benefits. Physical, mental, you generally have to treat that, meaning, okay, I had a bad physical injury. I had such a rotten shoulder, tear up that, now also I have maybe stress disorders or some other emotional component of it. You have to treat that as an employer. All the effects of the injury are treatable. And then the mental, physical, that's a bit like the heart attack. If some part of the mind or body triggers a heart attack or true falling out, fainting, things of that nature, if there's a physical injury involved, then it's covered too. So generally, there's a lot of proof that's required for a claimant, but they're compensable injuries nonetheless. All right, so we now know what our employees have to show to get benefits. What do they get? I could summarize it, and this is what I used to do when I represented claimants. So, you get three things. And we don't even have to look at screens, but we will. And it's just this. While you are unable to work and the doctor's treating you, you get temporary benefits, 2/3 of your paycheck subject to a cap, right? And that's your temporary, either partial, if you can work a little, or temporary total disability benefits. And once you reach MMI, the doctor says, I've done all medical science can do to heal you. If you are permanently injured, permanently damaged, some part of your body is permanently changed from helping you earn wages, you're entitled to some either permanent partial or maybe permanent total disability benefits. And the other benefit is the medical treatment. Now, you don't get anything else, okay? 2/3 of your paycheck subject to a cap. It's not a whole lot in Mississippi. I think that we'll go over it in a second, but the cap on it is somewhere $530, okay, per week. That's the max. So again, disability benefits, medical benefits. There is this notion, it's in the statute, called maintenance during vocational rehabilitation. I think it was like $10 a week, and they raised it to a whole $20 a week, and I haven't seen that awarded in 20 years. If somebody dies from a work injury, there are some additional death benefits. We'll cover those in a second. So, compensation, the paycheck for not being able to work. As I said, it can be the temporary part until they hit MMI, or permanent if the body's permanently damaged afterwards. It is 2/3 of your average weekly wage. An average weekly wage is a kind of a legal term. You take, if somebody's worked 52 weeks, you take all their wages, add it up, and divide by 52. If they took a week vacation, you add it all up and divide by 51. If they've only been there for 26 weeks, you add up the 26 weeks of wages and divide by 26. What happens if somebody's been there about 2 or 3 days and they get hurt? Congratulations, you picked a winner for a new employee. But what you'll do then is take similarly situated employees and figure their average weekly wage, kind of present that, and that's how you would go forward with it. Now, in Mississippi, the most you can get if you are paralyzed from the neck down, 450 weeks at $551.02. So, just shy of $250,000. And I can tell you that that's not a lot for somebody that's tragically injured, that made, let's say, you're a welder and you're making $1,500 a week, especially a welder. That's nothing. And so it is capped. Now, everybody gets it, but you don't get everything you're entitled to. Again, temporary total, we covered that. The waiting period, we get questions on that a lot. All right, so you get hurt, you get the old paper cut, you got to go to the doctor, you miss a half a day. Do you get paid 2/3 your lost wages for that day? No. The employee has to have missed or lost some wage for 5 days. Doesn't have to be consecutive. Maybe misses a half a day on Monday to go to therapy, and by the 5th week, he's missed 5. From that point on, you would pay him each day of disability until day 14, when you would go back and pay him the loss per week. So you start to dribble them in from day 6 through 14, and after day 14, you'll pay 2/3 the average weekly wage per week that they're out of work. Permanent and total. Again, this doesn't mean permanently in a wheelchair, never able to get out, do anything. I mean, that's common sense, but what that really means in workers' comp law is that they are unable to find a reasonable vocation. And the example we always give, if you got an 8th grade education and you're a welder and you've been doing it for 30 years, you could have a moderate injury, maybe loss of one hand. You're never going to really get a job again. I could probably be in a wheelchair and still be a lawyer. So there is a kind of a shakeout as to who is permanently and totally disabled. Judges decide it. It's kind of a smell test, and if it's the case, then they get 2/3 their average weekly wage for 450 weeks. That's the cap. You never pay them another dime afterwards. Permanent partial, we kind of split it up as lawyers. They're scheduled and unscheduled. A scheduled member injury, they're listed. There's like 14 of them, and they're listed in the code book. Your eye, your hand, your finger, your arm, your leg. And there's a prescribed number of weeks of benefits you get. So if I hurt my arm, it's 200 weeks of benefits if the injury is to my arm. And we know this because a lot of the orthopedic doctors, when they give an impairment rating, let's say he's got a 5% disability to his arm, right? So we would do 5 times 200 times 2/3 of his paycheck to figure out the scheduled member award. Unscheduled is anything that's not in the 14 categories of body parts. This is your neck, your back, emotional injuries, anything else but a scheduled member injury. You get 450 weeks for those, but you don't go by the impairment rating. Instead, you consider what their wage loss is. So you could have someone with a very serious unscheduled injury, and if you bring them back to work making the same wages and the same job, they have a 0 permanent partial disability, similar to the case Carl talked about earlier. And so again, I guess the takeaway as an employer, if you want to trim your workers' comp costs, as a carrier, you want employers to trim their workers' comp costs by bringing the employees back to work. You can really drive value out of a case in a neck and back injury. Remember, that's 450 weeks. It's a lot of weeks. You bring them back to work and limit what they can claim as a wage loss. On the medical side of things, medical, I'd say 10 years ago, exceeded indemnity in the amount of dollars employers in Mississippi paid. Okay, back 10, 11, 12, 15 years ago, employers, if somebody got hurt over the course of a year, all the employers, they do their stats, more people got indemnity benefits than the employers had to pay out for medical treatment. That is so reversed now. Medical treatment is the big ticket item. And so a lot more of the issues, contests are arising on the medical side of things. Again, the statute says the employer and carrier has to furnish all the medical treatment that's reasonable and necessary to restore the worker back to as close to his original condition as possible. The medical benefits are for life, okay? So if a guy has sort of a permanent shoulder injury and he needs to go see the doctor every 6 months for an injection and some therapy, if he's hurt at work, you are on the hook until he is in the grave or she is in the grave. It is a long-term prospect. Reasonable, necessary, and causally related to employment. And again, that's where a lot of fights come up. Guy has bad health to begin with, old bad back, maybe he's getting chiropractic treatment. It says he's strained it more at work. You got to pay a little, and do you owe medical treatment for life, back treatment? And again, a lot of it shakes out as to what the doctor says, what's old, what's new. But if it's causally related to the employment, you will be paying for it. Now, it's not totally up to the doctor what treatment he gets. What we have, Mississippi, is kind of in most states, a system that probably could stand some improvement. We call it utilization review. And it's supposed to work like this. Guy gets hurt, goes to the doctor says, okay, I need to do an MRI on your knee. That order goes to the carrier, all right, the employer's insurance carrier. They'll send it to utilization review. And they'll look at it and say, hey, is this treatment in line? I mean, guy hurts his knee. I mean, he doesn't need shoulder injections, right? So, I mean, you kind of look, is this close? It's in the ballpark. 2, if the doctor ordered 50 visits of physical therapy right off the bat, you'd say, time out. 14's kind of the normal course, right? So it gets reviewed. And if the utilization review person says this is excessive, or it's not related, they got to kick it to a nurse or somebody in the medical field to kind of review it. That's your second level review. You can at that point also divert and hire your own physician. We call that the EME, or Employer's Medical Examination Physician. And what you try to do is, okay, you got orthopedic trying to do all this kooky care. You better get another orthopedic doctor to review and give a second opinion as to whether this care is reasonable, necessary, and will provide some utility. It will improve the worker's condition. Now, where it gets tricky is the unreasonable delay in providing medical treatment can open up the employer and carrier to a claim of bad faith. So if you're going to say no to medical treatment, you better be cautious and careful and prepared and have what we would say is a reasonable and articulate basis to say no or to delay. You're entitled to your EME and your review. But if your EME or reviewing every single order, you're probably not acting in bad faith. Your carriers and the utilization review folks have a pretty good sense of when to flag something for extra scrutiny. In Mississippi, we also have an ExParte Rule. What that means is this: an employer and their carrier, they are free to talk to the injured worker's doctor all day long about everything, unless and until a legal proceeding is filed. And in workers' comp in Mississippi, we call that the petition to controvert. And it's basically like filing the lawsuit. Once that occurs, you can have no communication on your own with the physician. All right. So let's talk about on your own. You can still send a letter to the physician if a petition's filed. You can still, as an employer, send a letter to the physician as long as you copy and bring in the employee or the employee's lawyer also and have a shared communication. And a lot of times you need this because if you're a good employer, you make a light duty job and you have questions about, well, is this within their light duty? Is this outside their light duty? You know who we need to talk to? Your doctor. I know you're kind of suing us. We're working through that. Let's jointly and copy you on the questions to the doctor. Hey, can they do, I had one come up where the lady needs BLS certification or life-saving certification. And I guess you got to, do some physical acts. She's under some restrictions. So, we had to sort of team up with her and get to her doctor and get him to clear her to recertify her life-saving skills and do that for a day. So it was no problem. We couldn't do it on our own. The penalty, if we'd have called the doctor on our own, is if he sort of lessens or lightens the restrictions. That's not going to be, first, it's not going to be evidence later that they can do a job. And there's a case from a few years ago, it's on the borderline of egregious ex parte. The employee sued him, breach of privacy, breach of HIPAA protection, bad faith, all the claims. It kind of washed out because it wasn't that bad a case of facts. But again, if you want to get lit up as an employer, violate the ex parte rule, and you will. The employees and employees' lawyers will sue you. Death benefits. If somebody dies in the line of scope of their employment, first thing you got to do is stroke $1,000 check to the widow or widower. Is that what you call a guy who's, widower? And then you have to pay up to $5,000 as an employer of their funeral expense. And then the statute awards benefits for 450 weeks. And if it's a dependency statute, so if your worker is single and has no dependent kids, all you got to do is write like $1,000 check to the second injury fund. If the employee who dies is married and has dependents, and if they have a dependent spouse and spouse alone, it's 35% of their average weekly wage, again, subject to that 550 cap for this year. And if they have children, you kind of add 10%, 15% if there's no spouse, but they have to be dependent children. And you can also have dependent brothers, sisters, moms, and dads. They can come in. These are dependents. And how do you prove dependency? Tax returns, who's your dependents. Occasionally we have contests over who's dependent on the wage earner for support. All right, bad faith, the big troublesome bad faith. Bad faith claims are an exception to the workers' comp exclusivity rule. And when we throw that out, lawyers say exclusivity rule means this. If you have 5 or more employees and someone gets hurt on the job, no matter how bad as an employer you screwed up to injure this person or hurt this person, The only thing they get from you is workers' comp benefits, right? That's the exclusive remedy of an injured employee, is to get those workers' comp benefits. And it's handled through the Mississippi Work Comp Commission, right? But if you unlawfully and in bad faith deny workers' comp benefits, then you go over there to the circuit court, be sued in tort, as we say. And the damages that they can seek are not limited to the PPD, TTD, or medical. Instead, they can get emotional distress, pain and suffering. They can get punitive damages. The jury could award an open-ended amount of damages against an employer that engages in bad faith, an adjuster that engages in bad faith, an insurance company that engages in bad faith. The damages are not only set by a jury, which are unknown. You're in a whole new court system called circuit court here in Mississippi. You could be dragged into rural circuit courts where it's bonanza in front of a jury. So here's how we avoid bad faith. To prove bad faith, you had to have a contract for workers' comp insurance, or any insurance really, but we're talking about workers' comp today, that there's a denial of a claim without a legitimate and arguable reason, okay? No good reason you said no. And then they also, to succeed against you as an employer or carrier, there has to be some other evidence of ill will, spite, intentional conduct, heinous acts. And usually that gets proven by pulling a claim file or all the communications from an employer to a carrier, and get all those emails when they find stuff like, he was a rotten employee, we need to be extra hard on him. Well, that's probably going to bite you. You got to treat everybody the same. He might have been a bad employee, but you give him the same, credit, if you will, under the workers' comp system. You'll never get an employer or a carrier down there and say, yeah, we hated him and treated him bad. And so the evidence is usually these little pockets of talking bad about the employee, not having a written basis for why something was denied or delayed, not getting things reviewed by either lawyers or doctors, making your own decision that really is for experts. That's how they'll show that the denial was willful or intentional or maliciously wrong. A couple of examples. These are cases over the years that employers got successfully sued by the employee for bad faith. Terminating benefits, workers' comp benefits, simply because the claimant reached MMI. Remember, when they are done treating, they're not done with workers' comp. If they have a permanent injury, they're entitled to their permanent benefits. If you just don't pay them, it's intentional. They are legally entitled to them. The other one is the failure to make an adequate investigation, meaning you didn't chase down all the leads before you said no. If the claimant says, this guy saw it, you need to talk to this guy, okay? If the claimant says, well, my doctor told me that this is what's happening, well, we don't have the records yet. Well, you must go get the records before you say no. Okay? You must investigate fully before you say no. Withholding benefits to force a settlement. This is the classic case. I know I owe you this paycheck. I'm not going to pay it. Maybe you missed your mortgage. Or how about this lowball settlement over here? You'll get rung up for that every time as an employer and a carrier. So we talked about failing to pay the scheduled member impairment rating awarded by the treating physician. So if they have a scheduled member injury, it says 30% to the arm, don't delay. It's there. Pay it right away. There's an old case, Cook Power and Light. This is the case. And the power company had to stroke an extra check because they refused to pay a scheduled member benefit. You can require the employee to bring forth evidence. You can. But the best thing to do for bad faith, to avoid it, if you're going to require more investigation, there's a form called a B-52. Your carrier may do it for you. As an employer, you need to see that it gets done to avoid the whole allegation of bad faith. And it just states, we're not paying you yet because you haven't brought us the proof to pay you. Here it is in writing. We're telling you now. We've asked for it. You haven't done it. We're denying your claim because you haven't brought it to us. Once you do that, you won't have to pay penalties and interest if benefits are awarded later. Okay? And you weigh that in front of you. Listen, we told the guy, you ain't done your job yet to prove your case. We were very upfront, very open, and very honest with about it. You're probably dodging bad faith by filing the B-52. As an employer, look, don't hide the claim. If the guy says he got hurt, sit down, fill out the first report of injury, send it to your carrier. A lot of bad faith cases arise when the employer just doesn't believe the employee, doesn't find him credible, and refuses to report the claim. The guy doesn't get his treatment. Maybe he has a heart attack. Things get worse later. You're on the path to bad faith. Mentioned it earlier, assume your claim file and your communication will be evidence in the case against you later. Everything that happens needs to be documented. It didn't happen unless it's documented. And at the same time, know full well, I get every communication I can nowadays. Cases are proved with text messages and emails, right? Who's been watching the Johnny Depp, Amber Heard deal, right? I mean, text messages, Same with like the Sussman trial that's going on. One of the key pieces of evidence was a text that the Sussman sent to the FBI saying, I'm doing this on my own, not on behalf of the Clinton campaign. That is Exhibit A. So again, your communications need to be businesslike, professional, and contain nothing that can be construed as slander or an insult to the employee. If you're ever in doubt about a workers' comp claim, whether to pay it, how to investigate it, where you do, he's got 2 thumbs and he's got a get out of jail free card. It's right here. If you ask me what my opinion is, and I say to you, listen, you don't have to pay that because he hasn't done this or you haven't seen this. The advice of counsel, legitimate advice of counsel, is a defense to a bad faith claim. All right. So if you're in doubt, call a lawyer. And if you get good, reasonable, legal advice, you'll never get sued successfully for bad faith. Okay. Because you relied on allegedly an expert. Okay. And I think now we've talked about how you owe the benefits and what you owe. There's a few ways to sort of rebut that and to limit your exposure, and Carl will handle that for us.
So all of you pull out your book that you have with all the guideline for employers and carriers and look at the index of that book. And I'll add a lot of the things that Tristan talked about too. There's more information. Basically, what we're doing is a very high level outline of the book that you have. So if you look at your index, you're going to see one that says defenses and ways to reduce liability. And what I'm going to do now is go through those. And what we believe is, as I mentioned earlier, the Mississippi Workers' Compensation Act is not very big, and it's a narrow scope. And I think we're going to present to you every defense we think is available that you can reduce liability. In lots of other types of law, it's a lot more open, but we're not. We're statutory basic rules, and we're going to cover each one of those. Some of them are rare, some of them are common, some of them are different. So we'll start. The first one's jurisdiction. Jurisdiction is the power of a court, in this case, the commission, to decide what goes on in a case. And the thing we want to emphasize here is when you have concurrent jurisdiction, meaning jurisdiction in more than one state, or jurisdiction between the state and the federal. So for example, you have a Mississippi resident, he lives in Mississippi, he's injured in Tennessee. He could file his comp case both in Mississippi or in Tennessee. And that happens sometimes. And what the point we have it in the book is that if that happens and he goes to one state, he or she goes to one state and receives an award and then goes to another state trying to get more money, the employer and carrier are going to be entitled to a credit for the amount of monies that you paid. Maybe not the attorney's fees piece, but for the monies that you've paid, so that he cannot receive more than they're entitled to under either state. Mississippi is not the only state, but many states do not have this exemption about maritime. So in a situation where what it says is the Mississippi law clearly exempts maritime. Maritime would be Admiralty, be Jones Act, or it could be the Longshore and Harbor Workers Act, the federal workers' comp claim. And I have seen many times where a claimant's attorney doesn't know which one. He'd rather have Longshore, but he wants to be careful. He files his claim both under the Longshore Act and the State Comp Act. And when he does that in Mississippi, if you'll call your Mississippi lawyer, if you'll call us, we will get the state comp case dismissed under this statute. Because if he's claiming maritime, he cannot have the state comp. There is no concurrent jurisdiction when there's a maritime claim. Now, switching gears under jurisdiction, Many states, workers' comp applies to all employees. Sometimes it's 2. Mississippi, it's less than 5. So if you have 1, 2, 3, or 4 employees only, then you're not required to have Mississippi workers' compensation insurance. If you have 5 or more, it's not that you're just required, it's a crime in Mississippi. The principals of a corporation can be held personally liable for not having workers' compensation. It's a misdemeanor, but you can go to jail for up to a year. I've never seen that happen, but you can be fined for not having workers' comp. And I cannot tell you, I've had several examples of owner's exemption issues where I have a small company, the contractor has employees. He will say, I don't have to have workers' comp because I only have 4 employees. I'll ask him, well, are you working? Are you using a hammer too out on the job? Well, yeah, but I'm the owner and I don't have to do it. That's not true. You can get an exemption. If you're an owner of a small company, if you file with the commission, they will exempt you, and then you don't have to have workers' comp if you're the employee. But if you don't get the exemption, you've just violated the law. You're one of the employees and you've hit number 5 or number 6. So if you're a small employer, you need to know that. Apportionment, Tristan touched on it. Apportionment was very popular for long years, then it went away with the case. In 2012, it's back. And I have been very successful with the apportionment defense. The concept of the apportionment defense is it only applies when a claimant reaches maximum medical improvement. It does not apply to medical bills. But when a claimant reaches maximum medical improvement, you go to the claimant's doctor or you get an EME, I'll talk about that in a minute, and you ask the doctor to address what percentage of the disability is due to a pre-existing condition. So if in fact there is a percentage due to a pre-existing condition, then you don't have to pay that. It takes a lot of work many times in litigation to find the records to show that a claimant had a pre-existing condition. And what you're going to look for is another back claim. If you can get records and x-rays, it's not difficult. Under the AMA Guidelines 6th edition, which is what the doctors go by, there's page 25 and 26 that directs the doctors on how and why they should apportion. So if you have a guy who's hurt his knee, he gets a 10% rating, he goes back to work, hurts his knee again, now he gets a 20% rating. You're going to ask the doctor to say what percentage, and this ought to be a no-brainer, right? What do we think? Should he get 20% or 10%? Who says 10%? Who says 20%? Y'all not with me? Yeah, 20%. 20. So you got a guy hurt his knee, he gets a 10% impairment rating, and he gets his money for 10. Now he's re-injured his knee, and they give him a 20%. But for apportionment, he'll get what? 20%. But because of apportionment, if the doctor says 10% is attributable to the first injury where he got his 10, he's only going to receive 10%. That's the way apportionment works.
Does the employee refuse for the insurance company to get his past medical record?
We'll have his case dismissed. We'll file a motion to dismiss.
Carl, can you state that to the question? I don't think the
Yeah,
video
good.
answered.
Yeah, for those on virtual, the question was, what happens if the employee refuses to sign a HIPAA release so you can get the records in the past? And we'll file a motion to compel the HIPAA release. And if they ultimately refuse to share it, then we can get the case dismissed.
You can
Claimant
also
will be
compel,
the claimant is not entitled to deny access to those records.
you can file a third-party subpoena as well in the workers' comp system to force the release of those medical records.
Statute of limitations. The statute of limitations starts as a very simple proposition. If you are injured on the job and you don't file your petition to controvert in 2 years, then the claim's barred. You've missed your chance to file your comp claim. Mississippi has a little different extra twist to that, though, because in Mississippi, that 2-year statute applies to a medical-only claim, meaning if you're not out of work in the 2-year period of time and you only get medical benefits, the 2-year statute applies. Now, that rule has been attacked by legal authorities because there's a little piece of unfairness in it. They say you can have an innocent claimant, everything's fine. He goes to the doctor for 2 years. He's not yet released from the doctor, but if he doesn't file his petition, he's going to get a letter from the adjuster saying his claim is closed. Now, this is conditioned upon the adjuster being sure not to make any promises, because there's case law on this. Promises about we're going to take care of you. Don't worry, we're going to pay all your doctor bills. You have to be sure you don't have that kind of factor in the situation before you close the case. But it's only medical only. Now, if and once the claimant misses work, and then the 2-year statute doesn't apply anymore. Once he misses work, then we have a separate way to close the case. You have to properly file a B31 form. And the 1-year statute begins when the file is properly formed. This is different from most every other state. I do a lot of work for multi-state adjusters, and this is the B31 form is always a challenge for them. It's got to be properly filed, and then once it's filed, if the claimant returns to the doctor within the year, you have to file another B31 form. In the book that you have in front of you, and those on virtual, you can download the book from our website. We've got a whole chapter dedicated to how to properly file the B31. It's called Closing the Case. Now, we also have a statute. If you read the book, it says that if you don't report your claim in 30 days, your claim's barred. But the case law has pretty much abolished that rule. It doesn't apply. It says only if you prove prejudice, and I've found there are no cases where they've used that 30-day rule. Be aware that claims can still be reopened after the statute's supposedly closed it for fraud or for mistake within a year after the case has been closed. Now, as I said, it was a simple rule, but the courts find ways to make things more complicated. And so these are the exceptions to the rule that you have to apply when you're dealing with statutes. And one of them is the wages in lieu compensation rule that sometimes can be really complicated. But the basic premise is that if the employer pays wages instead of the workers' comp carrier paying the disability benefits, then that can cause you to lose the 2-year statute of limitations and the 1-year statute will apply. And I have seen this quite a few times. Many of you adjusters that are listening to me have seen the same thing. Today's times, an employer will have a claimant report an injury. Doesn't seem to be a very serious injury, so the employer will not report it to the workers' comp carrier, and they'll just pay the wages and they'll pay the medical bills. And that can go on sometimes. They don't want to see their mod go up. They don't want to see their workers' comp premium go up. So they'll pay it themselves until such times the claimant comes in and says, well, the doctor says I need surgery. Then they're going to decide to turn it into the workers' comp carrier. And so if the 2-year statute's gone, if it's 2 years have gone by, the adjuster may want to say, well, the 2 years is gone, you hadn't filed your petition. Well, this wages in lieu rule will stop that because they're going to count those wages that were paid to that claimant just as if the workers' comp carrier had been paying disability. And it can get complicated after that. The latent injury rule, that applies in most every area of law. The statute of limitations does not begin to run until a claimant knew or should have known that they have a work injury. And most of the time it's obvious. I broke my leg on the job, so we know that you have a work injury, the 2 years starts. But there are some medical situations, and Tristan alluded to one. We have a lot of asbestosis on the Mississippi Gulf Coast, and asbestos is a medical condition where you can be exposed to asbestos, you can get it in your lungs, and you don't know about it. It does not manifest, according to the medical literature now, for 15 years, or even they say 20 years, till you find out that you have asbestosis. So you didn't know. And so the 2-year statute does not start until that doctor tells you you have a medical condition, you have asbestosis, and it came from your work, and that's when it would start. And of course, that gets complicated, but that's the latent injury rule. If an employer lies to the claimant, the injured worker, and says, we don't have any comp insurance. The guy says, hey, I got hurt in the job. And the employer says, well, we don't have comp insurance. And 2 years goes by. The courts are not going to allow that. They're going to equitably toll or not apply the statute of limitations based upon that fraudulent statement. And there's one case that gives us some concern. When you have a work injury, The employer is a part of this. You should prepare the B3 form, the initial report of injury. Some adjusters let the employer do it. Sometimes you report it to the insurance company. They prepare that B3, the initial report. There's a case that suggests, and that case has got some other intentional misrepresentation in it, that if you don't properly file the B3 on time, the statute doesn't start. You should prepare a B3 on a medical-only claim. You don't file it with the commission. But if you have an injury, which is lost time, then you must file your B3. And we encourage employers not to forget that form and always file it to protect you against this case that suggests that may be a problem with the statute. Independent contractors. For those of you who participated last year in our seminar, I spent 30 minutes on this exact topic. It's a used, still hot topic in America today. You can watch Uber over in California is where it's the biggest one, where they claim their people that work for them are independent contractors. There's a big move that's saying no, the Uber people are employees. In California, they got some legislation, and I believe right now Uber people are independent contractors, but it's not over yet. And so if you have people that you have contractors and you have people that work for you, you'd be surprised how many smaller companies want to declare them all to be independent contractors. If they're independent contractors, then you don't have any obligation to pay workers' comp. But if they're not independent contractors and they're employees, of course, you've got troubles not only with workers' comp, you've got a lot of troubles with the IRS as well. That's what I talked about last year. A contract between the employer and the independent contractor, which says this is an independent contract, is not enough. They're going to look at exactly what the facts are, and the facts, in a nutshell, is whether or not the principal controls the actions of the worker. The more control the principal has over the worker, then the more likely that you do have an employee and you don't have an independent contractor. And once again, the book talks a lot more about that. Now, in the construction industry, there's this concept of statutory employers. So in the construction industry, you're going to have an owner. He hires a general contractor. The general contractor hires a subcontractor. And in Mississippi, we've got cases where the sub hires a sub of a subcontractor. And the way it usually works in construction, and when it starts, is the owner says you need workers' comp insurance, and the general tells the sub he needs comp insurance, and the sub tells the sub of the sub you need comp insurance. And when it starts, usually all of them do have comp insurance, and you get a certificate from your agent to get, I've got comp insurance. But my experience has been after a year goes by, or a long time contract, 2 years goes by, Mr. Sub of the sub doesn't pay the premium on his comp insurance. And Mr. Sub doesn't get his comp insurance, and then an injury goes to the sub of the sub, and the question is whether there's comp insurance. And the statutory employer rule says there's going to be comp insurance. So if the sub of the sub doesn't have it, the sub's going to pay. His workers' comp's going to pay. If the sub doesn't have it, then the contractor's comp's going to pay. And that happens a lot, where the contractor's the comp. And the comp insurance people know that. They ask questions, they put premiums on it, and that's the statutory employer rule. Dual employment is a concept we have all seen. It's very common with employee leasing, where, Express Pro here in town or Kelly Girls and these companies, you're the owner and you hire leased employees. They work for you. You treat them like employees as far as control and tell them what to do. And so the courts have made it a rule for dual employment that they have the same immunity from lawsuits as if either one has the immunity. And then there's usually, either one could be required to provide workers' comp. In real life, my experience has been with the professional leasing companies, it's in their contracts who provides the workers' comp. Usually it's the lessee, the Express Pro company, they W-2 the employee and they provide the comp, but it's all decided, so it doesn't come up very often. Loan servant is just what it says. You've got employer A, you got employer B. There's a case like that where employer A loaned an employee to go work over there to employer B to fix something, and then he gets hurt over there, and the question is, who is responsible for workers' comp? And in most of the time, it's the loaned servant, the one that he's working for, that's going to be responsible for workers' comp. but it's an investigative thing if you have that situation comes up where you have to do your investigation. Subsequent intervening cause. So this is a defense that you're always looking for to see if something has happened after your injury that might be the real cause of the injury. And this is the law, you can read it. Every natural consequence that flows as a direct and natural result of the injury and also arises out of the injury is compensable, but if the independent intervening agency interrupts the chain at any point, then liability of the employer and carrier ceases. So you have a guy, he's a delivery man driving down the road, and he's already had his workers' comp case, and he's been injured, and he's getting his workers' comp, and then he gets rear-ended, and he's got the same injuries this time. He hurts his knee again, just like he did the first time. If you can get the doctor to say that now the real cause of this man's future problems with his knee is due to the second car wreck, then the first carrier, we're out, will be dismissed. And that's what you look for always. That's why all workers' comp files need to be carefully monitored for the entire life of the comp claim. You don't stop your investigation just at the beginning of a claim. It should continue. And that's a reason why Tristan mentioned too, you want to avoid bad faith by that too. You always need to keep monitoring your comp claims. If you're an employer, you need to keep up with what's going on in your workers' comp claims by talking to your adjuster on a regular basis, requiring them to provide you information of what happens with your comp case. Quasi-scope of employment rule is one that's created by the courts in a situation where you're doing something you would not have done but for the fact that you have a workers' comp injury. And my example that I've seen is physical therapy. You know, you get hurt, they send you to the physical therapist. Every once in a while, you'll have some person injured at the physical therapy place. They lifted something too much or got a twist and got a new aggravation. That's going to be covered under the initial work injury, even though you could say, well, it's a physical therapist's fault. That might be something else, but workers' comp is going to cover anything that you get injured on that you would have been doing but for the fact that you had a work injury. Fraudulent inducement is a defense that the Mississippi Supreme Court has not recognized. They don't have a case, but they've indicated they would recognize it in the event that it arises. Now, with the ADA, and you make a conditional offer of employment, you don't get to learn the medical records until the conditional offer of employment has been made and accepted, and then you can have a medical questionnaire, then you can have a medical examination. That's when it would come up, is when an employee lies and says they did not have a work injury when in fact they did. And this happens. Employees, I've deposed them, they said, yeah, I lied because I knew I wouldn't get the job if they knew I had the prior injury. So I'm going to tell them I didn't have anything. And so this rule would allow that if an employee lies, says they didn't have any problems, and then they get injured in that same body part, you can deny the claim. And so we don't have a case yet, but it's something you ought to look at when you have an employee and they fill it out and you can catch them in a lie. I like deviation. Deviation is the concept that you can be on the clock, you can be working, but if you take a little time off for a personal reason, then you're not going, the employer and carrier is not liable for the personal reason. We've got this old case with the milkman who goes, knocks on the door, and the lady of the house comes to the door and lets him in, and the milkman and the lady of the house go in the bedroom and do a little deviating when the husband comes home and he shoots him. He shoots the milkman, and the milkman files his comp claim. Now, who says he should get comp? Who says it should be denied? And y'all are right. The courts denied that claim. Now, the courts, though, always expand things. So you've got the next rule that says in the course test. And in the course test says that if the worker is doing something that is incidental to employment, then it can be compensable even if it is a deviation. And there's a line of cases, the Good Samaritan cases, where the driver is driving down the road and a lady or a man, either one's on the side of the road with a flat tire, and he drives over and he helps the flat tire. In this particular case, the driver steps back into the highway and gets himself run over. So then he files his workers' comp claim. And the employer denied it because he shouldn't have been helping him on the side of the road. But the courts found in that case that that was something that benefited the employer, seeing the truck's name and him helping the person on the side of the road, and they awarded comp. Now, in that case, they didn't raise the question of whether the employer had a rule that prohibited him from doing just that. And you know, many times in the big trucking industries, there's rules now. They tell them you cannot be a good Samaritan. And so that might have changed the facts in the case, but that's the in the course test. This is the same type of thing I mentioned earlier about a rule with exceptions. This should be so simple. If you're going to work and you're not on the clock and you get injured, it's not a comp case. You're not on the clock. You're not working. And if you leave work and you clock out, then you're not on the clock either, and you shouldn't get comp. And that's the going and coming rule, and that's still the rule. But I got a long list, and these aren't all of them, of exceptions that the court has made to find ways to award comp in the going and coming cases. First, the traveling employee. Got a case that a man was in Jackson, was going to go to the seminar in Biloxi for a work-related seminar, gets injured on the wreck. They found that's compensable. He wasn't on the clock. He wasn't being paid, but because he was doing something in furtherance of the employer's interest by going to the seminar, it was found compensable. If you allow your employees to have company trucks, and maybe some of your companies do, many do, that's if he gets injured in the company truck, it's workers' comp. He's not on the clock, but it's still going to be workers' comp. Now, you can argue under those if he's in the company truck on personal time and there's some rules, you know, that he's doing something not work-related, maybe not. But the going and coming rule, the man's not clocking in. He's got the company truck, but he hadn't clocked in. It's going to be compensable. The parking lot cases, really, I don't like these cases. So the rules are that if a claimant is injured in the parking lot of the employer, even though he hasn't clocked in, it's going to be compensable. There's a case where it wasn't even in the employer's parking lot. He was in a parking lot, a public parking lot, that he had to walk through the employer's parking lot to park in, and they found that one to be compensable. And these cases are all ones where the employee, I mean, I can see the sympathy factor. The employee was mugged in the parking lot is what happened, and so he filed a comp claim because he was mugged in the employer's parking lot. Compensable. Now, I agree with the personal comfort activities. If you're on the clock or not, if you're on the clock and you have to go to the restroom, technically that's not work, right? But the courts have found that if you got to go to the restroom or personal comfort, some medical things like that, those are going to be covered, and they should be. Now, the last one's one that I like, this hazards, a single route hazards. I'm in Pascagoula, and of course, Ingalls Shipyard is here. And Ingalls Shipyard has got an interstate highway just about from Highway 90 to the shipyard. I mean, it's a big, wide, is it 4 lanes or 6 lanes, Randy? Probably 6-lane highway going to the yard. On this particular case, there was work being done, construction on the roadway, and so the guy somehow got his car damaged on the construction on the roadway, and he had not clocked in, but they found, since that was the only way he could get to work was down that road, then that was found to be compensable as well. So you can see the exceptions are pretty wide. Third-party claims. Third-party claims, the first party is going to be the claimant, second party is the employer and carrier. The third party is an outside third party. So this is a case where your driver's driving down the road on the clock and he gets rear-ended and gets injured. And so comp pays all of his medical bills as indemnity under comp. But in comp, there's no money for pain and suffering. There's not, the wage loss is limited. There's lots of other damages you can get in a tort case. So he files his suit against the third party who has insurance because the third party was at fault. Tort case, circuit court, can be a jury trial. And what we want you to know here in Mississippi, and not all states are the same, that if that person gets a judgment, our statute provides that the plaintiff's lawyer gets the first cut out of the money. The second cut goes to us, the workers' comp carrier. Then Medicaid, Medicare, Blue Cross, medical bills, they all have to be paid. And only then does the plaintiff receive what's left. Now, in reality, what happens most of the time is there's not enough insurance of the third party to pay all the bills. And so in reality, we have a big group meetings, and the workers' comp carrier, the Blue Cross, Medicare, Medicaid, they all will reduce their liens in order to get the worker, the injured person, some money in order to resolve them. So that's how our statute works. Intoxication, illegal drugs, and improper prescriptions. The law was changed in 2012. So if you get a hot test, pop a hot, somebody referred to that the other day. You pop a hot for a positive drug test on an illegal drug. You get a positive drug test because you have abused your prescription. So you do more than what your prescribed prescription says on either the prescription by the doctor's instructions or the label, or 0.08% of blood alcohol, which is, that's the legal rate for driving, or you refuse the blood test. Any one of those four things, then the law presumes that your injury was caused by your illegal drug use. And you deny the claim, there's a presumption of that. The presumption can be overcome. And so this changed it from what it was before. I'm going to talk a little louder because of the train. Let's stop. I'm going to talk a little louder. If you can't hear me because of the train, I could stop. But I'll talk a little louder. If, in fact, you do these things, then the employer and carrier can deny the claim. They'll file the B-52 that Tristan talked about. The claimant can still rebut that presumption. And I had a case where the claimant said, yes, I tested positive for morphine, but I had poppy seeds in my muffin for breakfast this morning. And do you know that medical science backs that up? That poppy seeds in muffins and bread will get a false positive for opiates. And so it can be rebutted sometimes. And then there's other factors. Willful intent to injure. Our statute provides that if you're trying to attempt suicide and injure yourself, that it's not compensable. Willful intent also, if you have a co-employee injuring another co-employee and it was intentional and it was because of non-work related reasons, even if it's on the employer's dirt, it's not going to be compensable. So if you have Jack and John getting into a fight because John's been messing around with Jack's wife off premises, that would be a personal reason, and that would not be compensable. So that's another reason why investigations are really important. Early investigations into injuries. Don't assume anything. You might find that's the case, and you can deny the claim. If you have a third party that intentionally injures an employee, it's compensable only if there's a work connection to it. So I believe that a drive-by shooting where the employee's just standing there and it's somebody drive by, that's not going to be compensable. It's got nothing to do with work. On the other hand, there's a case where a disgruntled ex-employee went to the premises and with a machine gun and just rattled it off because of work. That made that case compensable for the people that got shot. Now, there's an exception. There's exceptions all through our law. The exception is the zone of special danger. In the zone of special danger exception, you will not have to prove the work connection. And the example is taxi cab drivers who drive in the bad parts of the city where the crime is just prevalent. Because that crime is prevalent, that's kind of part of the job. And because that's the work connection, if you can show the zone of special danger, you won't have to prove, the claimant would not have to prove the work connection because it's going to be included in that zone. The imported danger doctrine is one that's, the example is the guy goes to work and he's got some firecrackers and he's playing with the firecrackers and they blow up and he injures himself and a coworker. Okay, so does the worker get workers' comp, the guy who brought the firecrackers? Who says yes? Who says no? And y'all are right, no. Does the worker, the other worker, the innocent worker who got injured with the firecrackers, does he get paid? And he does, exactly. That's the imported danger doctrine. Acts of God, the rule is Acts of God, damages from hurricanes or wind damage or events are not going to be compensable. However, the courts have found exceptions to the Acts of God rule. The most common exception is workers out in a field to get hit by lightning. They have found those to be compensable. So you can't just automatically deny on a wind event. Many times you'll have to just dig down deep to see whether or not it's compensable or not. Kristen touched on the average weekly wage. This is one in this section as well, on the average weekly wage. Many times you'll find adjusters, I've found, where they don't always get the 52-week wage statement properly filled out. I encourage you employers to make sure the 52-week wage statement's properly filled out each week. If there's 50 weeks, then you divide it by 50 if they didn't work the full 52. If you don't have 52 weeks, then you shift to the statute of whether whatever weeks you have are just and fair. I usually always require the employer to give me 3 similarly situated workers, and then I average that, and usually the judges and the claimant's lawyer agree to that. EMEs and IMEs. EME is employer's medical exam. IME is independent medical exam. You can get confused if you do longshore work, because in longshore we only call them IMEs. Some in the medical world call them SMOs, second medical opinions. It's the same basic thing as an EME. An EME is employers and carriers don't have a lot of rights under the Workers' Comp Act, but we have a right to require a claimant to submit to a medical examination by a doctor of our choosing. Now, that doctor is our agent. We can talk. Tristan talked about the ExParte Rule. It does not apply to EME doctors. We can talk to our EME doctors. We can discuss what goes on in the cases. We send the claimant to the EME doctor. I'm a really strong advocate of having a letter written to the EME doctor, explaining what the file is, have a set of written questions to the EME doctor so they know what this is about and they'll answer the questions for you. It's really important. Most of the EME doctors want actual films. Those are not as easy to get as they sound. You've got to go to where they are. You got to get HIPAAs to get the films, but they need to see the films. As I was talking about earlier, in apportionment, finding those records for the pre-existing conditions and films are really important on pursuing that apportionment defense. The IME is very different. The IME, independent medical exam, there's a court order that selects the doctor. The judge selects the doctor. And note, you can't talk to the doctor. And I still try to get a letter written to the IME doctor. I worked with claimants' lawyers. One didn't want my stationery on the letter. We both signed the letter, but it's just more, you get a much better result if you'll do a letter to the doctor, attach all the records, and have questions to the doctors. The judges will generally approve it unless a claimant's lawyer objects. I had a case where the claimant's lawyer objected. It was the worst disaster I've ever had. The doctor didn't apparently see all the records. He didn't answer any of the questions that were relevant. We had fits trying to get anything done. So I really believe in that, but it's not required, and the court can't require it. It's really important to realize that when you look at the history of cases in Mississippi, many, many times the judges or the appellate courts choose the EME doctor's opinion over the treating physician. So EMEs, although they're very expensive, are very successful in workers' comp. If it goes, the IME doctors usually are not used until you have a treating physician says one thing and the EME doctor says something else. Sometimes then the judge will appoint an IME doctor to call the tie. And whatever the IME doctor says usually is what happens. So sometimes you have to pick and choose whether you want to press for an IME or not. It depends on the strength of your EME doctor. I mentioned earlier vocational rehabilitation. That's if you have a non-scheduled injury, as Tristan talked about, it's going to be the body of the whole cases, and you have a loss of wage earning capacity issue, you almost have to have a voc person, and the right voc person is very important. We have ones that we prefer. Be aware, though, that the law does not require the claimant to meet with the voc rehab expert. It's better. Most claimants' lawyers allow it, but they don't have to, and the voc guy girl can still do their opinions based upon records without having the actual interview. Surveillance is also a very good technique. And just a friend of mine says it's always good to take a peek sometimes. I like to set up the surveillance because of expense. I'll have the surveillance investigator know when there's a doctor's appointment, so they'll be there at the doctor's appointment, so they'll see the claimant out. Sometimes you can pay an investigator to sit at a guy or girl's house for a week and they don't ever come out of the house, or they come out and they don't catch them. So there are ways you want to try to reduce costs, but they are very successful. I've been most successful with the surveillance at settlements, because you can get a case settled when you show the claimant the video. He's already testified, now you can show he's lied about it. And they are helpful too in settlements with the judges as well. Second injury fund is a very weak under the State Comp Act. It's not like the Longshore Second Injury Fund that pays a lot of money. In Mississippi, under the State Comp Act, the Second Injury Fund is limited to scheduled injuries. That would be eyes, eyes, legs, hands. And so the rule is that if you lose one eye, you've already been paid for it, and now you have a second injury, and now you're blind with both eyes. The second injury will pay for the eye, so you'll get paid again for two eyes, or legs, or arms. Not much to that. All right, I don't know what time it is exactly now. Well, we're going to break for 15 minutes. So y'all come back and we will head into the employment section. I think all of you will really enjoy the next part of our day. If y'all have any questions about any that's happened this morning, Tristan and I, April are here to answer questions. Stacy Zorn has entered the room. She's back here and she'll be a speaker today as well.
So, getting
Not great. Two of them.
Yes. Over there. Which? Work here.
Candace not? I know, I know.
But, yeah.
Oh my gosh, this isn't hard.
Yeah, lawyers, you never want lawyers. We treat you.
Other than soup.
Say that again?
Friday, or someone presented while I was on day, so.
Well, cool. Okay. Too hot or too cold? Just right? Because, you know, like in our office. 6 to 1. Yeah. Look. Hey, say so. So they have that space.
So how do double every month?
It is. We're heating and cooling everything. It's like a competition. I remember one time I'm back to. I didn't mind. Couldn't drive a car. That's what it is. I'm getting bored. Oh, much drive. Like about temperature. Everybody's too hot right now. Everybody's too cold right now. But find something too hot. One layer of clothing. One layer of clothing over. Find it out. Basically, I should say, I ain't doing the squat. Who's trying to tell me to get there and shut up? And I was like, well done, bus driver. Well played. Of course, that was the trip. Sat down. And next thing is burning. Yeah. After the one with a cold beer. And then the one to see his guns. Like, we gonna get along just fine. The rest of you people may not make it. Here's my buddy. Yeah, he was so. He was something. Yeah, duffel bag filled with cold Budweiser. But it's okay. But at least I stand next to you, we're buddies. Everybody else is going down in the haze of bullets. See you, brother. I'll see you later. But we made it without incident. See you. There's no song. I pick a box. And one guy, like, you can leave this one. Wait. And then go to the bus station. Other people there. No gate one, leaving at 8. It's just like, you gotta have the bus driver. You call Greyhound and fall out. Bus station. And they were like walk to the car, leave. I don't know. See my love. Think I heard it. They're on bad as they are. They got Greyhound beef. That I can attribute. And And after that experience, 6 months later, let's come down here. Yeah, kind of like old. With the Amtrak. Like a Boston. Old poor guy. Nobody at the window. There's no sign. Nope, not doing it again. Oh, please make it. 3 hours. Oh, going through. Bullet train and. Man, I look at it, hey, we were stuck on the middle. Apparently, I got on one of the buses. Finally, I had like. Fill up, fill up, fill up. Right in front of her, the little lady. I sit there, the little lady. I couldn't carry her. I scooted over and like it's here. Man, I look back at that guy. He like smashed the kid. He's like, yeah. He didn't make it. I know you have gray hair for a good man. Apparently smell like beer. Otherwise you're having guns, but yeah, bring him back. That's buddy. I saw you. I saw you.
Let's see. Let's stand right there. And then,
And
no.
here, I have my stuff over here.
wait, no, she's just gonna stand over here. Then I'll say something and I'll move away and you'll be the next. Okay. Good. Gonna wait 2 more minutes for the instructions to come back. 2 minutes to show time.
I'm Dusty. Hey, Dusty.
She is the president of Gulf Coast Human Resources Association. She took Cindy Black's plan.
I live in Memphis.
Do you know Stephanie Taylor, the paralegal? Which else snakes from him in September?
Sure,
Who works for Joy?
Yeah,
Okay.
you know,
I haven't met her yet.
okay.
But
She's outstanding.
I'm surprised that I haven't met her yet. But typically I deal straight with Joy or Adrian.
And you see mostly the troubled employees and she stays out of trouble.
That's right.
You're the principal.
Stephanie stays out of
That's
trouble.
right. You're in trouble, you may
That's
see
right.
me.
That's right.
You only see me when you're in trouble. Your cancer
That's
died.
the way it's supposed to be, isn't it?
Yeah.
I think so.
No.
One more minute. We'll go live.
Alicia was listening.
I think as long as you're close to your podium.
When you finish, you want to say you turn it over to April McDonald for the correct rule? Good. And I'm just going to sit down. All right, ladies and gentlemen, we're going to go back live again. We welcome all of you back to our seminar, and now we're going to shift over away from workers' comp, which has always been famous to be a very boring topic, over to something maybe a little more interesting, into the federal world of employment law. and we're hoping you'll get something from that. I want to point out to you that we have handed out our evaluations form. And so please, before you leave, if you'll fill that out and just leave it at the back, we'd really appreciate that. And for those of you that are virtual, you'll be able to download the form, and we really encourage you to fill that out for us as well. We use that a lot to try to decide what we're going to do for the next year, and we think that it's beneficial to everyone.
Actually, Carl, online, they'll get like a click here to complete the survey.
So I don't know if you heard Tristan, he said you will, if you're virtual, you're going to get a click to complete the survey online. So you won't, that'll be good. If you have any other questions, feel free to call the office. You can ask for Terry. We can answer all the questions you may need to have. We appreciate all of you being here. As you know, and we are so proud to be co-sponsoring this with the Gulf Coast Human Resource Association. We've always had some HR people. Cynthia Black, I think, was at the original seminar that I taught over 30-something years ago, who's the past president. And we worked together with them on various occasions. And so I've asked Dusty Pisarich, who is the now president of Gulf Coast Human Resource Association, to welcome you all for this second piece, and I turn the podium over to her.
Okay, hi, as he said, I'm Dusty Pisarich, the current president for the Gulf Coast Human Resource Association, and we are very grateful to partner today. For any of you that are looking for professional development credits for your SHRM, if you are in person, there are some certificates in the back of the room, and we will also have them uploaded on the webinar tab of the website. So if you are joining virtually, you'll be able to get that on the website. And we welcome you to the second half, and I would like to introduce April McDonald for contract review.
Good morning or afternoon. What time is it?
Good morning.
All right. Good morning. That's right. I've been up since about 4:30, so I was sitting over here yawning. I don't know what time of day it is, but this year we added a new topic, contract review. I have not been doing this for 30 years, so I'm not as good as Carl, so y'all bear with me. But I'm going to talk about contract review in the sense of, okay, your business is going to enter into a contract. What might you need to know? First, I'm going to go through a short checklist that you can use when deciding whether or not internal review is good enough, or if you may need external review by your legal counsel. Internal review by staff is good for routine contracts, but external review by counsel just brings that outside knowledge, that experience to help guide you through what may be foreign contract terms. So, initial review by staff, is that enough? Typically, the more simplistic and routine the contract, the more comfortable you can be with internal review, but ask yourself these questions to help you decide. Is the contract single transaction or multiple transaction? A single transaction contract is, a single purchase, a single sale. If it's single transaction, you can get away generally with internal review. If it's a multifaceted, really complicated transaction, then you may want legal help. Does the contract contemplate performance beyond 90 days? If the contract will be completed in less than 90 days, internal review may be enough. But if completion of that contract will extend beyond that 90-day mark, you may want to consider having your attorney review the contract. How much is the contract worth? If the total dollars owed or due under the contract is more than $25,000, then consider having your attorney review it. If it's less, internal review may be all you need. Is this the first transaction with the counterparty? If this is your first time contracting with the other party, then attorney review may be needed. But if this is a business that you contract with regularly, you're familiar with them, you're familiar with their form contract, you may be comfortable with just internal review. Is the contract for non-routine activity, or is it for some highly specialized service? This kind of builds on the previous factor. If it's a contract that isn't routine, if it's highly specialized service with some company that serves some limited or really niche market, then you may want your attorney to review the contract before execution. But if it's your lawn care contract that you enter into year after year, you know what it says, then internal review is going to be sufficient for that. So you've gone through the first factors and you've decided, okay, internal review, I think we can handle this. You still need to know what provisions are important to look for in contracts. And so I'll go over now some of the things that you'll need to determine. Is the counterparty well known? Do they have a well-established reputation for doing business? If not, you may not want to enter into the contract, but if you still do, perhaps consider having your attorney review for extra protection. Is the counterparty creditworthy? Determine how many employees the counterparty has, what's their reputation, do a Google search, just find out as much information about them as possible before you enter into a contract with them. Is anything on the contract left blank? You should never sign a contract that have blanks. Many companies use form contracts. They have spaces where you can write in your own terms. So at minimum, write in not applicable. Don't leave any blanks. Are all the terms both clear and in correct quantifiable terms? Make sure the contract clearly addresses price, duration, square footage, whatever the case may be. Never sign a contract that has some uncertain terms. I can't tell you how many times a client calls with a contract dispute. I look at the contract, I question them, okay, how long did the other party have to complete their job under the contract? Well, the contract doesn't say, but we agreed to 30 days. That's a problem. If you're agreeing to it, put it in the contract. Look for whether the contract has any automatic renewal terms. If so, when that time comes, is the renewal even desired? Oftentimes contracts will have that automatic renewal unless you tell them, hey, I don't want this to renew, I want to terminate. So be sure when you sign a contract that may have automatic renewal terms, just notice those deadlines. Does the agreement shift the risk of loss for a casualty? This has to do with who has to carry insurance and will that insurance cover a loss if one occurs. So in addition to spelling out the requirement to carry insurance in the amount of X, I recommend obtaining actual certificates of insurance and store those with your contracts. Are there any indemnification or hold harmless provisions? Indemnification clauses are clauses in a contract that set out to protect one party from liability if a third party is harmed in any way. It contractually obligates one party to compensate the other party for any losses that occur. To go along with that, hold harmless provisions, they protect business owners from being sued when someone suffers damages on your property or when a service is being provided. So just know that if your contract has an indemnification or hold harmless provision, you're going to want to pay close attention to those terms. If you feel comfortable with internal review, great. If you don't, get some attorney advice. Are all reference documents attached to the contract? If your contract says see Exhibit A for certain terms, then make sure Exhibit A is attached. You should never sign a contract without all of those attachments. What are each party's obligations in the event of default. If they stop doing the work, or if someone stops paying you, what remedies are available? Be sure to pay attention to those certain provisions. How is a contract terminated? Is there a set deadline like I mentioned earlier? Does it automatically renew? Is there a notice requirement? Really, the preferred provision would be the option to terminate your contract at any time, 30 days notice, either party, without penalty. Be sure to pay attention to deadlines and important dates. Always review before signing and calendar any important dates that are included. Is there a warranty provision? A warranty is a written guarantee issued to a purchaser of a product or a service that the seller promises if anything isn't up to snuff, they'll come back and fix it within a certain period of time. So you need to review what warranties are in your contract, who they're from, what they're for. Are any warranties disclaimed or any warranties refused? Just be aware of that and review those terms. What are the representations made prior to the contract, and are those incorporated into your agreement? Sometimes parties will discuss terms, but then not everything ends up in the contract, in the writing, and sure enough, it'll be an issue. So just make sure that everything you discuss ends up in your contract. Is the jurisdiction and venue of any dispute centered locally near your location? Jurisdiction and venue really only comes into play if you have a lawsuit, but you don't want to have to travel to court in another city, in another state. So review those provisions, and if at all possible, be sure you don't agree to foreign jurisdiction. Is there a clause for alternative dispute resolution or arbitration? So if a conflict does arise, mediation or arbitration provisions will allow for those disputes to be handled outside of court. Look for those and decide whether you want to agree to those certain alternative dispute resolution provisions that are in your contract. Is there any paragraph or clause which is not clearly understood? If so, ask for clarification. The time to do that is before you enter into the contract. Don't sign a contract with any uncertainty. I know a lot of times also companies have forms and you think, oh, well, that's just what they offered. I have to sign that contract. Not true. Go back, get them to clarify. You can negotiate. You can mark this out. I want to change this. Just work together with the other party and get those terms that you want and make sure that you clearly understand what they are. Is any confidential or proprietary information required to be disclosed during the fulfillment of a contract? If so, that needs to be protected. You may need to include additional confidentiality or sensitive information provisions within your contract in order to avoid disclosure of proprietary information. Is the counterparty adequately insured to be on your company's premises? If they are, you may want to obtain a certificate of insurance, or maybe even consider being added as an additional insured on their insurance policy. Are waivers of liability present? Ideally, a waiver of liability clause will be mutual, and it'll provide that each party will be responsible for its own negligence. So check those terms. I would recommend having those included in any contract. Are consequential damages waived? Consequential damages are those damages that can be proven to have occurred between the failure of one party to meet an obligation. So a waiver waives those types of claims between two parties for those consequential damages arising out of or relating to that particular contract. I know that's a lot of legal mumbo jumbo. So if there are consequential damages waiver clauses you may not feel comfortable with internal review, call your attorney, ask them. Is subrogation for casualty loss waived? Subrogation is the substitution of one party or group by another in respect to a debt or insurance claim. You hear that a lot with insurance. They subrogate. If the insurance company has to pay out, they'll go get their money back from someone else. So a waiver of subrogation, an An owner may require this endorsement from their vendors to avoid being held liable for any claims that their insurance company has to pay. Pay attention to those, read the language carefully, call your attorney if you need extra help. All right, so those are just a few of the significant issues and terms that need to be reviewed before you sign a contract. If you're considering developing form contracts, those may be things that you want to put in there. So just be aware of those. And again, if you're ever in doubt, call me, call Stacy, Tristan, Carl. Any of us can help answer your questions in regards to your contracts. Next, I think we have Tristan. Oh, Stacy, remote work policies and issues.
Right. Good morning, everyone. Okay, so this is a new topic for me. Bear with me as I present you this presentation with some of the issues that I have found and policies that can be created to address those issues with remote work. And also, not only just legal issues, but there's some social issues that I think are very pertinent to the whole overall employment conversation as we go forward and navigate this new world with remote work. Okay, I'm going to try to see this. All right, how many of you before the pandemic hit in March 2020 worked remotely from home? Number one, was that full-time or sometimes? Full-time. Okay, so this statistic that I obtained said that before the pandemic, only 6% of Americans worked from home primarily, while 25% did some work from home. How many in here did some work from home prior to the pandemic? Okay. Now, after the pandemic, though, 35% of the employed workforce in America worked from home during that period where there was the shutdown. Obviously, not all industries can do work from home. If you were in goods and services, you still had to be there. But, you know, it was a huge impact on the way that we did things. And that trend still continues. So, especially with the professional and management sectors. Let me ask the people in the room today, how many of you worked from home from May 2020 through December 2020? Terry, one. Nobody else did? Did you? Okay, sorry, I couldn't see you over there. All right, how many worked sporadically from home? Okay. Well, this crowd then doesn't really go along with my whole conversation because I speak, you know, I talk to other employers in other industries where people are still working from home primarily. I was telling Ms. Snyder, I had a mediation with the EEOC the other day. My mediator was in New York, and she told me that they were going to start going back to work 1 day a week. And then by the end of the year, they were going to start going back into the office 2 days a week, which, you know, seems for some people good if you can balance it. For some, I just don't know how our America as we know it can continue to function if with this type of environment because of the impact that remote work has not only on the workforce in your office, but also every other industry that surrounds you. So what is the new normal? I'm going to have to get my book because I cannot see that far. All right, so many employees want to continue working remotely at least some of the time. How many people in here wish that they could work from home every Friday? Now, one thing that employers saw, though, as employees went to go work from home is that there was some satisfaction, at least during that time period of the shutdown. People were having more family time. They were being able to get things done at their house while they were also working. And I don't know if that was a combination of the whole environment with the COVID shutdown and what impact that had on the way we operated and everything, or if it was just in the workforce. But what we're seeing is many employers are now offering increased flexibility in work hours. Have any of y'all offered your employees an opportunity to work a couple days from home and to work in the office a couple days from home? Hancock Bank. And ma'am, which were you?
So Sealing Deposit.
Okay. And what do y'all do?
We work for the Department of Defense and deposit parts for submarine, boats.
So is it your administrative and professional employees that can work from home, or do y'all give any of that opportunity to your laborers?
Well, the laborers know, because they have to be at the facility, but our engineers, we're looking at making this an option, because during the COVID pandemic, some of them worked from home. We found out they liked working from home, and another thing, just hiring new employees. In fact, we've just lost 3 employees going to another employer because they get the option to work.
Right.
So now we have something.
Well, and I'm seeing also, many colleagues that I work with are no longer going to have their brick and mortar business because they realize that we don't have to pay for this office and all of this equipment and all these taxes and insurance and other things that go along with it. We learned from the pandemic that we can get our work done from home, or I'm not aware of any place around here. There might be one in Harrison County, or there might be one that I'm just not aware of. Collaborative workspaces now. That's something that they're starting to see around the country, is just an office space where people can go share time throughout the week as you want to really A, interact with people, or B, just need a place to get away from your actual house. So what does the future look like for employment and people working from home? Do you think we'll ever get back to just the expectation? You know, when I think about my business is different. We're grinders, right? We have Terry and Casey back there can tell you they've got to be there 8 to 5. They've, you know, the office doesn't run if they aren't there running it. So I don't know that we'll ever be able to have that in our particular office, but there might be some businesses where the flexibility works. So another word that I'm starting to hear is company culture. How do you balance work from home, where these companies that are promoting people working from home to save time, save expenses, give better work-life balance, versus having a company culture where you still feel like you're part of the team, part of the company? Since nobody in here really spent a lot of time working from home, I don't know that y'all are going to be able to give me good examples about issues that you experienced where maybe you felt isolated from your co-employees, or we'll talk later about work from home fatigue. Some of the things that other industries, of course, across the country, in many other areas, New York, California, it's big issues they're seeing. So this is just a fun slide. I mean, we all have our opinions on work from home. When I mentioned something earlier, I saw Tristan give me a look like, what? Because he's not going to tolerate the whole work from home and no office. You know, it affects everything that we know. It's our normal. Everything that we know is being normal. What about the transportation industry? If you don't have people going into the office, are we going to need as many bus drivers, Uber drivers, you know, Amtrak, things like that? What about airplanes? People weren't flying to conferences. There was the effect on the airline industry. What about the coffee shop next door? People aren't eating out as much. They're eating from home. One of my favorite pandemic-induced features, and I've got some bankers in here, was mobile banking deposits. Now, bankers, was that something that was going to happen anyway, or was that a result of the pandemic?
We were gonna have it.
Okay, well, it's just so convenient, but it makes me concerned for the tellers. If all we have to do is take a picture of our check, why do we need, you know, what impact is that going to eventually have on that business? What about service organizations? I'm in Rotary, and some people are in Kiwanis Lions Club. Are we making as much of an impact in the community by, you know, that whole idea that people are still social distancing and needing to stay at home? I went to an event recently, and they had lanyards with your name tag on them. And I thought this was really neat for any of y'all who might want to use this idea for an event that you have for your company. A red lanyard meant stay 6 feet away, I'm still social distancing. A yellow meant I'll do a fist bump or, you know, wave. But the green was I'm a hugger, come as close as you want. And so those are little social signals now that people are using. Now here's my favorite.
And for any of you that don't know, Tristan is my husband, and I'm really trying to guilt him into getting me a golf cart. There was an increased interest in outdoor sports, including a huge market increase in the sales of golf carts as a result of the pandemic. I'm told, though, that there's also going to be a market decline and possibly the ability to buy them at a cheaper rate coming up soon. So anyway, fingers crossed. So, but those are some positive impacts that we had. I know Shell Landing was killing it during the pandemic because everybody wanted to go out and play golf. Okay, so now let's get though to what we're really here to talk about, the legal issues. So there are some legal issues that, you need to be aware of with remote work. We're here at a workers' compensation presentation, so I'll talk about workers' compensation, some expense reimbursement issues, work from home fatigue, productivity issues, and then any others that y'all want to speak about. So telecommuting is not a new thing. I mean, it's been around as long as we have been presenting this. We've always touched on telecommuting issues in our workers' comp presentation. But what type of issues do you typically see when you have somebody who telecommutes from home? There's overt injuries like slip and falls. I remember one example that we used to give is the person who trips over the extension cord leading from her computer to her wall because, it was placed out in the middle of the floor. Is that a compensable injury? But right now, the real focus is on these ergonomic injuries. And during the break, we had a good conversation about some of those things that we're seeing. Employees are were sent home, not necessarily with any oversight as to what their office looked like or their setup, or if they had an appropriate chair, appropriate keyboard. And my favorite place, I told y'all, was I like to work sitting in my bed, watching TV with papers laid all around me. That's an ergonomic nightmare, right? And then my son told me last night that his father took his gaming chair while he was doing some work because it was the other most comfortable chair in the house. We don't have an ergonomic setup. So the strain injuries, the carpal tunnel injuries, other things that are becoming more pronounced, at least in the insurance industry, is seeing more of them because there's more people at home being exposed to those type of unergonomic setups. Now, remember, all injuries must arise out of and in the course of employment, so the employee still has to prove their injury in order for it to be compensable. But what are some of the issues you can see about investigating those issues? Do you just take the employee's word for it? If we were in an office setting, you might have a witness. You might have somebody who observed the employee before the alleged injury or after the alleged injury. We're primarily defense attorneys, so we're here to tell you how to defend claims. But, the employee's not always bad, but, especially these, when it comes to compensation. With these type of injuries, though, they're so subjective that they often lead employers to a lot of, I guess, what's the word I'm looking for? Doubt, maybe, as to whether or not they should have to pay for them. So, yes, ma'am. No, go ahead, Ms. Snyder.
Well, if somebody is working at their home, wouldn't they have like homeowners insurance or something that would pay, even though because it's not a controlled environment, when they're coming, which is, an environment that is provided to them and they're at home, you have no control.
Lack of control is not going to be the deciding factor. If the injury arises out of it in the course and scope of employment, so they're sitting there doing your work and they haven't deviated, like we talked about the defenses, then they are essentially under your control for all intents and purposes, doing your work at your direction, and those injuries will be compensable. Homeowners would probably, April mentioned subrogation. If somebody filed a claim on homeowners.
I can tell you right now, the standard HO form homeowners policy specifically includes work and work-related activities from coverage.
Oh.
It's just not covered under homeowners.
And then there could be a subrogation issue if it was, and it later turned out to be a workers' comp injury.
Well, essentially, if you're designated.
That's correct. And so we'll talk a little bit about some of these issues, though. On the next slide, I'll come back to record keeping. So what can you do as an employer to reduce your remote work injuries. One of the things I'll skip down to is set fixed work hours and meal and rest periods so that there is some indication, at least from an employer, of when your employee is supposed to be working versus supposed to be doing personal errands. Now, this is kind of counterintuitive to this whole flexibility standard that employers are now going to allow their employees who traditionally work 9 to 5 to work from 8 a.m. to 12 p.m., take a 3-hour break to take care of kids, and then go back to work from 3 p.m. to, 6 p.m. or 7 p.m. But, you have the right to set the workday as the employer, and if you set those standards and if the employee's injured at 7:30 instead of when he's supposed to be working for you at 8:30, you might have a defense that maybe he wasn't in the course and scope of his employment when that injury occurred. Does that make sense? Ms. Snyder, I'm looking at you.
We had so many problems.
Right. Well, did anyone have a remote work policy that set forth the employer's expectations for employees working from home? Or was it, I know we were just kind of like a mass gathering, we've got to go, the world's coming to an end, get out of the office, you can't be within 6 feet of anybody. So a lot of that was done really without a lot of foresight initially. But then it continued. I can't believe it's been 2 years. Can anybody believe that it's been 2 years since the shutdown? It really seems like yesterday. So since that time, employers have had an opportunity to go back in and fix some of the problems that were created by the initial, flee. Establishing guidelines for a home office, you can tell your employees, don't be like Stacy. You're not going to go work in bed. You're going to have a designated office. We're going to provide you an ergonomic chair, an ergonomic keyboard, make sure that everything's set, appropriately so that we prohibit those injuries or prevent those injuries as much as possible. Conduct training related to workstation setup and safety measures. Imagine some of these people who live in really tiny places with a lot of stuff and very little space to move around. I'm thinking like a New York City apartment. How do you set up a safe workspace that also doesn't impinge too much upon their living space, where they can walk around and do what they need to do as part of your job? Are they bringing in materials? I should have a comp claim for my shoulder because I'm constantly bringing work home, but I would have a defense because as a mom, I rarely touch it after 5 p.m. But, there's those kind of things that come along with it. Do employers go to the employee's house and check their work areas? I mean, or do you just take their word for it? Can you virtually look around and make sure that everything's set up safely? And can you conduct safety training for them so that they know the best practices to help themselves and prevent injury? And then also early reporting. Encourage your employees anytime they feel a strain or a sprain or anything, report it early so that you have notice of it. Y'all can monitor it, get it treated early, make adjustments to prevent that from continuing to happen. All right, so I'm going to go back to record keeping issues with remote work. This isn't a new issue either. A lot of employers have people that work remotely in other states. Just understand that if you have an employee who lives in Alabama, your office is in Mississippi, but they're hired in Alabama and they work in Alabama and they're injured in Alabama, they may file a workers' comp claim in Alabama, and you as an employer need to talk to your insurance broker and make sure that you are covered in all states where you might have potential liability. So that's just something to look out for if you have employees in different states. All right, expense reimbursement. Expense reimbursements can go either way. Employers seeking reimbursement from employees or employees seeking reimbursement from employers, and we're going to talk about both of them. When the employer seeks reimbursement from an employee, the employer cannot dip into the employee's paycheck if that causes it to go under minimum wage for that work week or reduces his overtime that he earned for that work week. So typical things that you see are people having to buy uniforms for work, and the employer wants the employer buys the uniform and then wants the employee to reimburse it for the uniform. Well, if the employee makes $7.25 an hour, You're never going to be able to collect the cost of the uniform from him because it would always dip into minimum wage if that's all he ever worked was $7.25 an hour for 40 hours a week. If he made $7.75 though, the employer might be able to incrementally recover some of those expenses. And the DOL provides some other examples. Cost of a physical examination for these employees working at home. You can't dip into their minimum wage if you're going to send somebody out and you want to seek reimbursement for that. This is really a conversation though about remote work in the sense that what are people remotely working seeking reimbursement for, and what are employers seeking reimbursement from employees for remote work? So typically, in a regular setting, people use their personal vehicle for business purposes, you get reimbursed. What's the federal rate of reimbursement right now? Is it 56.5, 58.5? It teeters around there, cents per mile. Your business and travel expenses, your tools and equipment, your personal cell phone, talked about uniform. But now we're seeing reimbursement for expenses such as office supplies, internet access, and required equipment for your remote workers. How many people in here who had remote workers had people working in rural areas that didn't have access to the internet or very low internet coverage? So did y'all have to get some sort of Wi-Fi set up for them or hotspot or something?
What ended up happening was they had to get like an updated router to have it work, and if not, they were going to have to come into continue working.
Okay, and we're going to have a little dialogue about that. If that reimbursement was the employer said, you cannot come to the office, you have to work from home, but you have to buy this router in order to work from home, would the employer not be required, but would it be right for the employer to reimburse the employee for the cost of that router or pay for that router? I see my ladies in the back going, yes. But if it's the employee's choice as to whether or not they want to work from home or whether they have the opportunity to come in the office, should the employer have to reimburse for the cost of the router? No? Okay. And again, that's not necessarily a legal issue. It's an employer policy. It's what you want to do as an employer to provide those reimbursements to your employees. This is an interesting slide. What is the cost of working remotely? So one of the studies that I've cited in my citations came from the Dutch government. It valued an employee, the cost of working remotely, to be $429 to cover things like coffee, tea, toilet paper, internet access, utilities. Those kind of things were considered, and they paid their employees that as a bonus to compensate them for the expenses that they had for working remotely.
For the whole 2 years?
I think that it was a yearly bonus, like it was the cost per year. Yeah, I mean, we get coffee, tea, soft drinks, and water at our office. So I just thought that was a real interesting thing. The Dutch might be a little more generous though than Americans. Right. So anything else anybody wants to discuss on reimbursements? Just remember, if you seek any reimbursements for your employee, you cannot dip into their minimum wage or overtime requirements. Those are set by week. And if you do have an employee who it looks like you're going to dip into it, just spread it out. It can be prorated, over a period of time so that you don't cut into their wages or their minimum wages. And I'll just go a step further. That's because the federal law requires that employees receive at least minimum wage for every hour worked over 40, or every hour worked in a week, and overtime for every hour worked over 40. Okay. This slide has a typo up top. This should say work from home fatigue, not WFH fatigue continued. And I take responsibility for that. So WFH stands for work from home fatigue. What is work from home fatigue? And again, I was really hoping to have some more work from home people in here. I can't believe it. I've talked to so many people out in the community that have been working home for so long. But maybe y'all have employees that are working from home that are experiencing this. So work from home fatigue is the feeling that virtual employees are getting, they're unmotivated, they're disconnected, they're dissatisfied with with their work and their working environment, and it's kind of dipping into some mental health issues. Now, I also talked to some people who are working from home just fine. They love it. So, this isn't true for everybody. So, this is just an article that brought out these. I read this article and I thought this was real interesting. You want to talk about some humanizing. I thought that there were 12 factors listed in this article about what causes work from home fatigue. And deprivation of our basic human need for significance and function. How many of us get some sort of identity from who we are in the work environment? We have friends, we have, acquaintances, we have a boss that gives you praise. Those kind of things are lacking in that work from home environment. You just don't have that human interaction, which also leads to a deprivation of our basic human need for connection. Again, this is not true to everybody. Some people love working from home. So for those of you out in the virtual world who don't feel this way, don't be offended. This is just a particular, person's opinion. But you can't also, another thing is how many people work from home don't feel like they can establish a relationship of trust with their coworkers. I mean, when you are able to be in person with somebody, engage their body motions and, their inflections in their face or, those kind of things, they really cues you as to whether or not somebody is being truthful or honest. Yes, sir.
I would say it's complicated by how well you already know them.
Right.
Because you already have a pre-established image of each other. But when you go into a new job market or meet new employees, peers,
That's a really good point. And from one of the studies that I was reading, that's exactly what they pointed out. If you all worked together first and then you went back and you started remote working, that was much better than people who just, met for the first time remotely. And some companies are doing things to curtail those issues by having like Zoom cocktail hours or, but going a step further and saying, hey, let's get together out in the real environment too. Let's go bowling. Let's have a team building experience. There's things that you can do as an employer to get people out from behind the screen so that they do have human interaction to curtail this work from home fatigue that people are experiencing. Deprivation of mentoring and informal training. I know I thrive in the workforce by seeing other people do things and you learn from them. I've been fortunate to learn from Carl for 19 years. He's been my mentor and I find myself doing things. My husband sometimes even calls me Carl. So, had we worked remotely, I would have been deprived of that mentoring and informal training.
Oh, no, it's all positive.
Oh my goodness. So I've already touched on number 5. It isn't just Zoom fatigue. It's really just that lack of human connection. See, I wouldn't have been so funny had we just been on Zoom, right? And then on Zoom, how many?
I get to go next.
He's going to be in competition as to who's the funniest. On Zoom, though, how many people are frustrated because you just see one black square, and if that person doesn't have their photo up or don't have their screen, they're not on video, all you see is a name, and so you can't see everything going on. Another thing, what older workers don't know how to use this technology, and so we do these Zoom depositions now as a lawyer, and people have this ability to put documents up onto the screen. I don't know how to do that. All I know how to do is hit go on my video. So, there's not as much opportunity for people who are technologically deprived to participate fully in Zoom meetings. Trying to force a square peg into a round hole. That's, what I talked about, Zoom happy hours. They're not the same as human interaction. So, and inadequate skills in remote and technology tools. I touched upon that with my Zoom skills. Absence of skills in effective remote communication. How important is it to being not only a successful business person, but being successful in life to learn how to communicate to others in your business. I mean, we have a story. When we first started doing this, I first started doing this seminar 19 years ago. I would do workers' comp and I'd get up to the podium and I'd, and over the years, you know, you just improve, and that comes with human interaction and the ability to communicate and feed off people. Let's see, inadequate skills and reliable remote collaboration. So voice tone and body language, we've talked about that. That's very crucial to getting social cues to know whether or not things are going well, or, you know, how to adapt in the workplace. Lack of accountability. This is where it can offend some people who are very good remote workers versus those that are not good remote workers. What is the accountability that employers can expect from people working remotely? We don't have it in our office, so I don't know what big companies do as far as, you know, do employees clock in on a computer and they are monitored all day to see how long they're away from their computer and things like that. You know, what can you do as an employer to hold your employees accountable for that time period? I'm almost finished. Okay. And then the poor work from home environment. We talked about the issues being in a small space or not having that work-family balance. If you're constantly inundated with having, you know, children around you while you're trying to work, not that children, you don't love your children, they're not lovely, you're just not able to balance between being a functional employee versus being mom or dad. And that goes also into poor work-life boundaries, which sometimes can trigger subpar performance and increase errors and burnout. So, anything else on work from home fatigue? All right, so what can we do to accommodate our employees and prevent some of these things from happening? We've talked about it, more flexibility, more paid time off. Some employers are granting floating holidays because one of the other issues is we hear about all these people that need jobs and we hear about all these businesses that need employees, but then why do the businesses still need employees if people still need jobs? The industry just has not come back the way that it was pre-pandemic, and we know that. And so other employees are having to do the job sometimes of 1, 2, 3 people working extreme hours, and there's a trend among companies to provide flexibility with floating holidays. Okay, you'll get off this time, you'll get off this time. And then let employees back into the community. The EEOC was an example. I spoke to another person in industry here. I've been trying to get a speaker from that particular industry since pre-pandemic, and I was told that they can go back into the community in September. It's what, May? So in September, this company is going to let their employees go back into the community, which is really interesting to me. And then mental health resources. Now, really, I want this to be a big takeaway for employers. Has anybody ever heard of an EAP? How many employers in here have an EAP? How many employers in here have used or referred an employee for EAP services in the past 2 years? Okay, you haven't had the opportunity to. Well, I know I'm running behind, I'm sorry, but anyway, just know that mental health, be aware of your employees' mental health, because some of these, you know, people still are suffering from the results of the pandemic and the shutdown and work-life balance issues. And so, you know, if you need an EAP program, consult with your insurance provider, consult with Singing River Hospital, they have one, and just be attuned to those issues. Okay, any other accommodations that you can consider or want to consider? And there's my citations and authorities, so I'm done. All right, 3 minutes over.
The last section for today, non-compete agreements. Everybody familiar with what a non-compete agreement is? Anybody here, just show hands real quick. Anybody subject to one? Do you know? Anybody's employer use them? All right. I get a lot of phone calls for this. This first year I brought it up at the seminar, but I know it's been an interesting topic for a lot of employers, especially, and employees call me from time to time, having signed one with maybe a little bit of regret. What is enforceable? You know, and I always say it like this: the general idea, these agreements are not favored at law. No state, no law says this is a great idea. These are called a restraint of trade. This is America, it's the land of capitalists, and it's the land of free labor, and it's the land of everybody having the right to compete and be free and work as they want to work and earn as they should earn. In any agreement, any written agreement between employers, we call that antitrust. You can't corner a market the same. You can't own somebody's right to work. All of those things they're disfavored at law. So if you want to fall into these exceptions, this is what you're going to have to do. You have to make an agreement that is enforceable. What is enforceable? Well, no matter how you write it, okay, again, this agreement being a restraint of trade, disfavored at law. If it's not right, you're not going to quite get it. Most states allow them. 3 states do not. There's 0 non-compete agreements that are enforceable in California, the Panhandle State, Oklahoma, and then, boy, my geography is kind of tough. I'm going to say just to the east of Montana is Iowa? No. There you go. That's how terrible I am. Somebody shoot me. Unenforceable at all. Now, the blue states, those are called blue pencil, and then the red states are called red pencil. And we'll get to what that means in a second. And then most of us are green. See, Mississippi, Alabama, where I practice, those are green states called Reformation states. And generally, and we'll cover a little bit more, but that means that if you booger up the agreement a little bit, the court can tailor it to make it right. All right, and we'll talk about how that happens. So again, big takeaway: restrictive covenants, non-compete agreements, generally disfavored. As an employer, if you want one on your employees, then you better get it right, because if you can blow a hole in it, it's gone. Okay, it'll be watered down. You have to do it right as the employer if you want it to be enforceable. The employer who's restraining the employee's trade has the burdens of proof in court that it is reasonable and that it is enforceable. They must be, here's the words, this is the magic part of it, reasonable as to time and space. All right, meaning you can't sit there and say you'll never work for anybody other than me ever again anywhere. Okay, totally unreasonable, never going to happen. How about you can't work in 3 states? How about you can't work for 5 years? And so you start tailoring it down until it gets reasonable. And reasonable is the word us lawyers and judges use when we can't state it in advance and we just want to hear the facts later and make up our mind, right? So the law is the pigs get fed and the hogs get slaughtered. They ought to put that in there. But if they're reasonable, they're enforceable. And that's another key takeaway. If you do it right, you can have your employees not unfairly compete against you. And I guess that, if anything, is the fundamental part. An employer should not try to use these agreements to create leverage over their employees. That's not what they're for. They're not to try to keep the employee from leaving. They're not to try to keep the employee in line. Instead, what they're to do is to protect the employer's proprietary information, who my customers are, how we do business, that training we gave you. We started you here, we've made you here. Now that we've invested in you, you can't take what we taught you, what you got from us, what we empowered you to do, and then hand it to our competitor. All right. If that's fundamentally what you're trying to prevent, you will win. You will succeed as an employer from preventing the raid on that intangible resource that you have given to the employees so they can do their job. Right. Common provisions, in addition to the non-compete, there's non-solicitation. That is both do not contact my customers that you learned of at work, but it's also this. If you leave, good for you, but do not call your whole department and say, I can bring you over to my new employer, okay? That's non-soliciting your co-employees also. That's typically in these agreements. You always should have in there anything that's a trade secret or is confidential information will remain that way. Whether you worked for a grocery store and now you're going to go work changing tires, that's fine. But whatever you learn from us that's confidential, you just can't put on Facebook, you can't sell to somebody or give to somebody, and you'll want that protection, and that's always enforceable. And again, the anti-rating or non-poaching. Requirements for enforceable non-compete agreement, remember this: no contract that is not supported by, here's the lawyer word, consideration is enforceable. Meaning, if you just sign a piece of paper that says you're going to give me $100, and I take that to court and sue you, I don't win. And here's why. I didn't give you anything in exchange for that promise of you paying me $100. Now, if I say, I don't know, I'll paint your car and you'll pay me $100. Well, now I've made a promise, and in that promise, I've exchanged for the $100. That's consideration. Doesn't have to always be cash. Some states will say your job, showing up and being able to work tomorrow and get paid is consideration. Mississippi is one of them. Continued employment is adequate consideration. There's a lot of states that say if you do not hand them a stack of cash or something more material, then you have not supplied consideration. So if you've got employees in a non-compete agreement that are working in different states, you might want to have that question answered because consideration is not uniform. Future work in Alabama and Mississippi, though, is valid consideration. As I said before, as long as you're protecting a legitimate business interest and it's reasonable in scope, duration, and geographic territory, your agreement should be enforceable. As we talked about, a real advantage is consideration. Common examples: new employment, a raise, a bonus, a stock offer, promotion. But again, continued employment is sufficient to make an agreement enforceable. Legitimate business interest, as we said, overall, as long as you're protecting your goodwill, your customer list, your trade names, trade secrets. You know, if you give someone specialized training, you pay to send them to schools and get certifications, that's going to make your non-compete agreement as an employer stand up. You have invested in the employee to the point where they're worth what you're paying them. They can't then take that to their competitor. It's a valid reason to enforce a non-compete agreement. The primary right of the employer is that of protecting the business from loss of customers by the activities of the former employees who have peculiar knowledge of and relationships with the employer's customers. That's the Timberlake case in Mississippi, and I couldn't say it any better myself. If your goal is to do that, you will have an enforceable agreement. We always get into this reasonable in scope. This is a conversation I have with clients. Is this reasonable? Well, you know, too often folks focus on, well, he works in Mississippi, so I'm going to have a non-compete in anywhere in Mississippi. Is that reasonable? No, that's arbitrary. Okay, because what if every customer he ever called on is in Tupelo, right? Why would you non-compete him here in Pascagoula, right? So it's all both in Mississippi, but it's not reasonable. And, you know, what a court would probably do if you said that, if he was down here competing or in the same industry and helping somebody grow and boom, you're probably not going to be able to restrain that. Probably going to lose that. And the court will say, listen, I know it says Mississippi. That's not too crazy to say one state, but it doesn't marry and match what he did for y'all. You're not competing down here in Pascagoula, or you haven't been. So again, the focus, the geographic scope should always be a fact-based test. Where's your company at? Where was it planning to grow? Where is this employee you want to restrain from competing against you? Where did he work? Where can he hurt your business interests that you invested in? That's the better approach to how you draft scope. Always a pre-existing customer, you can pretty much restrain that. Real issues get to be, again, we had planned to open up this new market. He knew it. We don't have anybody there. He didn't learn anybody from there. Can you restrain him from going into the new market you're both planning to go to? And again, if you can show you trained them and you were heading there, I think you get that. If you can't, you won't. Reasonable in duration. Look, it's almost becoming 2 years. Why? 2 years has been uniformly upheld as a reasonable period of time to restrain somebody. Now, I'll tell you that 2 years can be both shorter and longer. If you're in an industry, and I don't know what it is, maybe we'll find it one day, but where people just turn over every 6 months or, you know, high rates of turnover, maybe 6 months is reasonable. If you're in a highly developed technological industry where there's a lot of R&D, a lot of prior art, a lot of, you know, patentable and trade marketable intellectual property, 5 years could be reasonable. Okay. And again, it's just like clothing. You can buy a shirt off the rack or you can get one custom tailored. I can tell you which one's going to fit better, right? And it's the same with scope and duration. We talked about geographic territory. Again, I would focus more on the facts than the map, okay? Now, what you'll see in a lot of non-compete agreements, you need to have them if you're an employer. You need to be aware of them if you're an employee. Most of them say that if you violate the agreement and we prove you violate it, you will pay the attorney's fees and court costs. And I can assure you that is a fundamental provision of the contract, because getting somebody going to court, you almost always have to litigate these if they're violated. They're done with a preliminary hearing. You want to get to court early. There's no sense in getting your trial date 2 years from now. And because of that, there's bond issues that you have to post to get preliminary relief. As a lawyer, I got to drop everything and do it on kind of a rush basis. So you pay convenience store price for all of that. It racks up fast and quick. And being able to say to that violating employee, not only are we going to stop you from working, we're going to hand you the ticket for it, right? That is strong medicine for a runaway employee that's actually trying to hurt your interests, right? So you must have it. You always need to spell out that everybody agrees there's a violation. We can get what we call a TRO, or preliminary injunction. It's America. America's general rule is due process, meaning we don't take anything from you. We don't give you a bill. We don't keep you from working until you've had your day in court. And preliminary injunctions are a bit of an exception to that, meaning if I can go in without winning the case completely, but I can convince that judge that you're going to do harm, immediate harm to me, that cannot be repaired at a trial a year from now, then the judge will issue a temporary restraining order, immediately stopping that employee from going to work for your competitor. If you don't have that, you may be stuck just trying to say, well, they wrecked my business. I'm going to prove they wrecked my business and maybe get that out of that employee a few years later. That's never going to work. The injunctive relief is everything that you're really seeking in these. A very important clause that you need to have addressed also is venue and choice of law. So you're a Mississippi employer, but now the person works remote in Tennessee. All right. If you do not have in your agreement, we're going to apply Mississippi law. And if you run away to my competitor, I'm going to come, we agree, we come here to Jackson County, Mississippi. I'm gonna hire that crazy gray-haired lawyer to represent me, and you better show up here. If you don't have that in the contract, you're gonna have to leave here. You're gonna have to find a lawyer in Tennessee. You're gonna have to go to court in Tennessee. You're gonna be subject to Tennessee law. I don't even know what that is. And you're gonna have to try to enforce the agreement there in the home court of your runaway employee. So choice of law and venue is critical in these. I see a lot of arbitration. 2 years ago, got into a big, again, I'd say a high on the scale of technology. A whole division of a company ran away to a competitor. I mean, it was nasty business. They had arbitration. And I can tell you that arbitration sounds great on paper. It's cheaper than court, it's faster than court. Hey, but an arbitrator can't command the police to enjoin somebody. So you have to fight through all this arbitration, win, and then take that arbitration order and come over to a court of law to enforce it. You know what I said? Skip arbitration. Let's go down there to court. Let's go get our injunction. It took about 60 days. We did, and kind of bought the employer a year to kind of get their ducks in a row for this column of employees that all left in mass. Another key clause. See, 2 years is de facto reasonable, right? Well, what if they're violating it for 6 months, 7 months before you find out? And then it takes you another 3 months to get your injunction. So that's 10 months of the 2 years. You need to put in the agreement that if that happens, that period is told, okay? So the 2 years starts from the day they're enjoined, not the day they leave employment. If you don't have that in your agreement, and they wait the clock out on you, okay? There's one other little exception for Alabama. Anybody that's got a licensed profession, lawyer, doctor, dentist, I guess we kind of wrote the law for ourselves, right? They cannot be enjoined from working. Non-competes are not enforceable in Alabama against licensed professionals. So be wary of that, because I think engineers are going to qualify for that too. I got into it with a pharmacist. We couldn't non-compete, period, end story. Licensed professional. Confidentiality, we've talked about that. Inventions, kind of the same. You really want a strong, not in your non-compete, but a separate protection of your confidential information clauses and paragraphs really in your contract. Return of company property. If you don't have that in your employment agreement, Their computer, whose computer, well, we gave you the money, you reimbursed it, all the electronic information stored on that computer. If it's the employer's computer, it's the employer's. It's the employee's computer, it is the employee's. Know this, I'll sum it up in a basic rule. Anything the employee takes in their head, they may take with them. Anything that is reduced to a physical form, electronically stored information, a scrap of paper, belongs to the employer. All right, you can't take what's out of their head, but anytime it is sort of materialized, that belongs to the employer, unless the employee paid for it. Assignability is the last thing we'll talk about too. Most contracts are, these non-competes are non-assignable. As an employer, you'd like assignability because, hey, maybe one day you want to sell your business, right? And I've seen this too, an old non-compete, you want to hire this great employee, and they say, well, I got this non-compete agreement. And the non-compete agreement is between him and ABC Company. But ABC Company sold to XYZ Company 2 years ago. And that's why he wants to leave. XYZ, and they're like, if the agreement's non-assignable, it's a personal covenant between the old employer and the employee, it's not valid anymore. You could hire that guy as an employee. You as an employer would like assignability, all right? It makes the contract more valuable to the employer. As an employee, you don't want assignability, you want it personal. All right, how to enforce it? We kind of touched on this. Enforcement starts at your exit interview, right? And if you're a good employer and you got a good relationship, even if they're leaving for something bigger and better, you know, you should conduct an exit interview. You really should. You learn a lot about yourself. They're free to speak at that point. They don't need you anymore. You do learn where maybe as an employer you got room to improve, but also you get a sense where are you going? Who are you going to work for? That is your absolute first, the canary in the coal mine as to, am I going to have a problem with a non-compete agreement or enforcement? Gathering and preserving evidence. You know, an employee leaves, do you have kind of a procedure to save, catalog, and record emails, things of that nature? Why? Because if they're using company resources to get their new job, I've tangled with a company that their employee, while being paid, you know, lined up her accounts and got them all sort of ready, packaged and moved to take to the competitor during her 8 to 5 job. I mean, but he did a good job preserving evidence, had her dead to rights, and the hiring employer tried to say at first, they didn't know we had it all. Oh, we just hired her, you know, she just brought the accounts with her. And man, when we got through reading the emails, it was so deliberate. You know, punitive damages were on the table. The checks were flying, the apologies were going, and she volunteered for a 2-year non-competition and shipped off, okay? So evidence prevention and surveillance, I've done that too. We're not competing, really, because we followed you around and saw you make sales calls to all the old customers. So sometimes enforcement requires a little sleuthing. Cease and desist communications. It's usually the first stage in enforcement, right? You write the letter and says, you signed this non-compete, here it is attached. We have heard, learned, discovered, know that you are now working for a competitor. If you do not cease and desist, we sue you, all right? Temporary restraining order, that's usually what you have to prepare for first. You'll hire a lawyer to do that. And you want a lot of evidence that they are competing with you. I had a case we tried one time, and it was whether they were competing. Worked for a software company, went to work for another software company, but the subsequent software company says, you know, we're big and fancy, and these little people over here are not our competition. There was some overlap, and we kind of settled that one. I think we weren't going to prevail because it was going to be hard to show competition. Again, we talked about the litigating in what forum, and then the last one's damages. Again, you get some employer who's mad, and he is mad for good reason, because the employee took all that he gave him and took it to a competitor, and it's hard to be in business, right? Every day you got to get up and bring it, and to have an employee undermining you like that is painful. But I said to him, how much time and effort are you going to spend chasing down your losses from a guy that, you know, makes, you know, X number of dollars a year? It'd take him, if he turned over his entire salary to you, you know, it'd take him 20 years to pay you back. The injunction to me is everything. Occasionally, if you find that the new employer really enticed away the employee, you'll go after the new employer as well for the monetary damages, but focus on enjoining and preventing harm from the get-go. So those are the enforcement issues. one of the biggest ones I see too is this. All right, so you got a good salesperson, he leaves you to go to a competitor and he takes with him 6 great customers. Now, you want to enjoin that. And he says, well, you know, they were coming with me anyway. I didn't entice them away, blah, blah, blah. Who are the witnesses in the case? Your customers. And it's never a good spot for a business to be in, to be dragging their customers that they want to sell to down there to witness stand. It's always difficult. So you have to consider the business implications of making your customers witnesses in your lawsuit against your former employee. Provable financial losses. Yeah, all right, so maybe they took customers, but then there's other issues you need to consider. Like, let's say that customer was more of a kind of a cost spreader or loss leader. Were you really making money by losing that customer? Can you prove you're out? I know you're out revenue, but are you out profits? And in the lawsuits, you get damages for lost profits, not lost revenues, because if your expenses exceed your revenues, hey, good for you, you lost that account because you were losing money. So that can be an issue when you enforce these things for damages. The cost benefit of litigation is always the big question we got. You know, this employee's left. Yes, he's now competing with you, but he sucks as an employee, right? Is it really going to harm you? Because you're going to pay a lot of money to enforce this thing. A lot of attorney's fees, court costs, bonds, you name it. And then the cease and desist letter, I lean towards, if you send it, you better back it up. I get some employers like, look, let's just scare them a little. Man, I don't know, maybe it's because so many people sue so often nowadays. Nobody's scared of a lawyer anymore, lawyer letter anymore. It's chucking the trash. So I think if you're going to tell them to cease and desist, be prepared to back it up. We talked earlier about scope of agreement and how it can be reformed. The red pencil states, it means just this. If you have an employee working in a red pencil state, if you overreach in scope and overreach in duration, the court will then say, you've overreached, we're throwing out the entire covenant not to compete. They're just free to go, all right? Be careful of red pencil states. Blue pencil states, they're not much better. What they'll basically say is, okay, if you say 2 years, but the state of Mississippi, and it turns out really maybe just need to non-compete them in Jackson County or the Gulf Coast. Well, the 2 years will stay, but they'll get rid of the offending clause that's too broad of the geographic scope. So you still really don't have an enforceable agreement. It just tear out a vital part. Okay, that's the blue pencil law. Unfortunately, Mississippi, Alabama, we have the green, the reform state where the court will still allow you to non-compete or enforce your covenant against the runaway employee to the reasonable extent, even if you misdrafted it a little too broad. You still should not, get into this by making a good agreement on the front end, but you do have that. Mississippi has a real quirky exception as well. This is the Bain case. The thrust of the legal takeaway from the Bain case is that if you terminate, you got a great, you hired me, you paid me tons of money, sent me on vacation to Mexico to get you a non-compete agreement. So it's great, right? You go to fire the employee for bad reasons, bad faith reasons, just hostile kind of termination for no good reason. If that employee can go to the court and say, I was terminated for a bad faith reason, then the non-compete agreement, no matter how good it is unenforceable. It is an exception. And so you always need to say, did you document your reasons, and was it a good provable for cause reason for termination? Now, I'll say this Bain case is there was 2 things in there to me that stuck out more so than the bad faith termination. It was, the guy was like, they called him a sales manager, propane gas sales. I think he got paid by the hour. He traveled a lot. He went from one propane gas company to another propane gas company. The former employer who had the non-compete agreement, he's kind of a bad dude, bought the company, was kind of a real butt, and a lot of the letters were nasty and mean. I'll keep you from work, man. I'll put you in poverty, all this other stuff. And the guy was not, he was on the brink of, he's just such a lowly employee, you wouldn't non-compete him anyway. I think that was in the case, but I'm telling you, the law says that if you terminate somebody in bad faith, it's an exception to the at-will employment rule in Mississippi. You will have a non-enforceable non-compete agreement. Hiring someone with a non-compete, I just love that picture. What could go wrong? Spider farm next to nuclear power plant. And that's probably about what would happen. You always need to ask your employees, hey, have you signed a non-compete agreement? If you have, we need to look at it. If you're worried as an employer that they're prevented from working for you, look, kind of like the contract review with April said, if it's obvious, maybe you know it's trouble. If you absolutely have to have this employee, maybe you send it to me, we look at it, we ask the questions, is it reasonable in time, place, and scope? Can we aid this new employee in avoiding being restricted from working for us? See what the cease and desist letter says from the former employer. And then really you got to ask yourself, you want to defend yourself as an employer from being sued for hiring somebody under a non-compete agreement. The general answer is no, but there's always the exception, right? If you're going to hire an employee with a non-compete agreement, when you kind of, figure out early on if they got one, look at it. And sometimes non-compete agreements are not just in a straight employment contract. If they had a stock option agreement or retirement type package or some other stuff, you could find non-compete language in those agreements as well. So be thorough as the hiring employer, an employee, to make sure you've checked. And then when you hire somebody that's got under a non-compete agreement, put in the hiring letter, your job is X, your territory is going to be Y. We expect you to not contact prior customers. Spell out in writing, because it's not in writing, it didn't happen, the limits of their job so that it does not unfairly compete with their prior employer. And if you put that in the job offer letter to them, it's golden evidence later saying, as an employer, new employer, we didn't interfere with this contract. We didn't participate in any wrong. Okay, so you put words and language to avoid the competition in the offer and set the job up that way and follow through like that. Again, you can talk to a lawyer, and again, we'll kick the same, instead of trying to have one that's enforceable as an employer, we'll kind of put the other hat on and say, is it reasonable time, place, scope, all those other things? And was there consideration for the agreement? Is there anything we can tell this new hire we really want? Here's why you're not restricted from working to us. And then again, ask yourself this: if you do give the new hire letter, tailor out a job or rules for him that do not violate his prior non-compete agreement, is he going to be effective? If you think so, go forward. If you don't, maybe the juice isn't worth the squeeze. Okay, so carefully draft the employment offer in the job description, and that's the takeaway from that. If you're going to hire somebody under a non-compete, if you then hire the person, and then here comes prior employer. If you've done your homework, you may know that it's just a guy who's bitter and ticked off, and the agreement's not enforceable. But if you get a cease and desist letter, probably it's a good time to get a lawyer. But you got to evaluate the motivation. Is it bluster? Are they just trying to mess with you because you're competitors? Maybe it's paranoia on the other guy's part. Maybe the prior employer can be told, listen, I know we're in the same business, but we're sending them off to a new territory, or we're training them to do something different. Maybe you can end the paranoia. But ultimately, if you get a cease and desist letter, you need to be preparing for future litigation. All right. I always recommend formulating a response. Okay. If you've done everything right, if you've got a nice pre-hire letter that spells out why you're not competing, we're going to attach that and send it. Right. That's pretty good faith. So defending litigation commenced by the former employer. Even if everything goes right, know this: if you hire somebody under a non-compete agreement, you might get sued. You just got to weigh that into it, because, it's modern world, man. Everybody likes to sue. Tortious interference with a contract. There's a difference between the lawsuit against the employee and the judge saying he can't work for y'all. But there's another one: if you sort of get caught helping him break or breach his contract with his prior employer as a company, you could be sued for the tort of tortious interference with a contractual relationship, meaning former employer now gets to sue you and get into your company pockets for the damages caused by poaching an employee who brings with him maybe customers that are value, things of that nature. If you get one of these cease and desist letters, tender it to your liability insurer right away. Don't delay. That's a claim. And then get on the stick, preserve the emails, preserve the correspondence, do Do not delete or destroy anything, because in this day and age, if you're threatened with a lawsuit and you erase evidence, innocently or not, they're going to accuse you of spoiling the evidence. And what happens when you get to court is if they can show you spoiled, deleted, lost evidence, then it's presumed to be beneficial to them. Another one of those presumptions, and you're kind of fighting from behind. Any questions about non-compete agreements? How to get them, how to enforce them? All right. I know I talk fast.
Questions about anything else? Got any questions about anything that we've done? You know about? We ended early today for us, haven't we?
Yeah, and one more
Well,
thing on
so
evaluation. This year, you can tell it's a lot shorter than prior years. Let us know if you like the shorter or the longer version, because we're here to please, and if we have to do more, we do.
I don't know if you heard what Tristan said, but on the evaluations, take your time. We'd like to hear anything you have to say about the pros and the cons, ideas for other years, and all of those things. We really use them, we value them, put them together. Ms. Snyder, did you have a question?
Legislation about vaccines. You know, we try to send our HR person up to Massachusetts. They don't let anybody on the campus do vaccination, booster, not booster. And we have individuals that are still anti-vaxxers. Or we'll have a customer, subsidy 7, that says, okay, we're part of 6-year vessel, but we want that because coronavirus is still around, that if one person gets sick because they failed to be vaccinated. So is there any legislation that's just going to be moved?
I don't know of any legislation. Congress, to my knowledge, has not passed any laws. Everybody refers to the CDC. And as you know, the CDC has been historically contradictory at times. But the only thing I recommend to my clients is if you have a question, go to CDC and follow their guidelines. And that's the only thing I can suggest to you with someone who's going beyond CDC, that you might could at least say, look, we are going to abide by the CDC rules, and it doesn't go that far to have everybody excluded. And so that's the only answer. It's a very difficult problem for businesses on how to properly address it. We all agree we don't want to create any more people to be sick. On the other hand, the science, is questioned at times. And on the other hand, we must keep businesses going. And so this balance is just difficult. And I'm sure you have the challenge of different parts of the country seem to have different attitudes and pieces. So no, there's not, we're the lawyers, but there's no real substantive law that we can go and give you strength for. Yeah. Okay. It's a challenge.
April that issue. April, do you have anything to add to that with your?
Yeah,
April, come over here so the group can hear you. And repeat the question.
She was saying that some companies in other countries, employees, they have a 100% vaccination rate. And it really depends first on, is it a private employer or, a public employer, I guess. Private employers, if you want to make all your employees get vaccinated and they can't work for you otherwise, I would, unless they have a medical exception that they can prove and show you, then you,
Religious.
or the religious exception, then you can make all of them have a vaccination. I think the religious exception and the medical exception have been abused. I worked with an employee employer, sorry, when this first started coming about, that 5 different employees turned in their form requesting a religious waiver. They were all the same, printed off the internet. So those are really things that it's more difficult for us here, since we don't have legislation, we don't have the best guidance from the federal government to dictate when you should or shouldn't grant those exceptions. I agree, it's difficult. But I told my client to document, these are forms, maybe have an interview with them personally and see what other documentation, what other efforts you can make to make sure before you grant waivers. And ultimately, if they don't want to work for you and you don't accept it,
What
It
about in
is.
the private, I mean, in the public sector though, didn't your employer have some employees that were working on Air Force bases?
Yeah, so the employer that I'm speaking of had several contracts on bases that are federally funded, and those bases said, look, I'm sorry, your employees cannot come on our campus unless they've had their vaccine or proven this, this, and this. And if they didn't, then they had to go every morning on the employee's time and get tested and come with a negative test if they wanted to work for them. And so that was a big thing too. The employer was like, well, do we pay them while they're off getting tested for 30 minutes? Do we let them use their vacation time or sick time or whatever to go get these tests?
Who
And-
pays for the test?
Right, who pays for the test? So ultimately, they said, look, if you don't want to get if you don't want to get vaccinated to work this job, you take your own time, you pay for your own test, and you come every morning with a negative test. But I'm with you. It is very fact dependent. Every situation is different. Every employer is different. Every contract is different. So really, the best thing to do is call us and we'll help you. No, there's a lot of questions and there aren't really any answers.
Seniors that get vaccinated. They could not, they did graduate, they did not participate in graduation ceremony. They received no commission.
Oh, that's
That
tough.
was very.
Take that to the virtual.
No. I was going to say, the employer also that I worked with, they made it to where, you know what, you don't have to get your vaccination, but we don't have any jobs for you right now. Sorry. They didn't fire them, but if they're not working, they're not getting paid. And so a lot of the employees said, you know what, forget it. I'll get my vaccination. I'll go back to work. I mean, what do you do?
It's a huge crisis in America. It hasn't been resolved yet. And so we work through it the best we can. Any other questions? Well, on behalf of the Gulf Coast Human Resource Association and our law firm, we appreciate all of y'all being here today. I hope you've learned something. We thank all of you who participated on the virtual. We hope that you'll fill out the evaluation forms and be sure to get your certificates. And we hope all y'all stay dry today as you go outside in the rain. So thank you for coming.
They just go in. Yeah. And then like, I think I'm going to like this. I mean, no, I didn't look back. They need to do that. I mean, if they're less ever.